It is right for the acting Chief Justice to be vetted and eventually sworn into office. But like I did tell you, the Parliament's Appointment Committee will shortly be vetting him. Members of the committee are already seated, and our colleagues are on standby to bring us an update from what's happening from the Appointment Committee. And if you're just joining us, acting Chief Justice, Justice Paul Baffoe-Bonnie, will shortly be vetted by members of Parliament's Appointment Committee, and we're going to shortly be crossing over to bring you details of that. And as you know, the Justice Paul Baffoe-Bonnie was appointed by the President following the dismissal of the then Chief Justice Gertrude Arba-Tokonu, following that investigation into what the committee that did the investigation called inappropriate actions on her part. And so the President appointed the senior most on the bench at the Supreme Court, Justice Paul Baffoe-Bonnie, to replace her. And as we've been telling you, he's going to be vetted today by the Appointment Committee. We already know that the minority in the House is protesting against this vetting and is saying that it's not appropriate because the former Chief Justice was not properly relieved of her position. But of course, Parliament and the Appointment Committee still going ahead to vet him today. A lot of questions that will be asked of him as he faces members of the committee, both on the majority and minority side as well.
And so we are live, coming to you live from the vetting room inside Parliament, where the vetting of Chief Justice, Nominee Justice Paul Baffoe-Bonnie is expected to happen. Right now, there is a full representation from, justices of the Supreme Court, for instance. And you see a lot of them, Justice Perman, Justice Amadou Tanko, Justice Senyo Jamafe, and the rest of them, who have all come to throw their support behind, let's say, the senior most on the Supreme Court bench currently, who is in the person of Justice Paul Baffoe-Bonnie, who has been nominated for the role of the Chief Justice. So today, just in some few minutes to come, his vetting would happen. And already there are a number of traditional leaders as well who have shown up to provide their support. Indeed, I can tell you that there are committee members who have all come. Very soon I will show you the committee members and even those on the minority side. But just briefly, let me try to get a word from a former director of the Ghana School of Law, who happens to also be a judge at the Court of Appeal, Barima Yao Opon, as he's affectionately known. You're live on TV3 Ghana. Today happens to be the vetting. What are your expectations, really?
Well, I think my expectations are your expectations as well. And at the end of the day, we are just here to fulfill a very important constitutional provision. That's all.
To talk about the nominee himself, what are your expectations of him today?
Well, let's leave that to those who ask the questions and the general public. I think after that, if you ask me, I can also tell you what I had expected, but it won't be proper for me to take it from those who have been constitutionally mandated to do that. Thank you.
Thank you so much. So that is Berimaya Wapon, a former director of the Ghana School of Law, who also happens to be a judge at the Court of Appeal. Members on the minority from both sides are very well represented. As of now, we have those on the majority side as well as those on the minority side who have all come here to throw their support behind the Chief Justice nominee. I will seek to get some few words from some of the members on the committee on their expectation going into this vetting. Nothing much, just some few words. I have with me Madina Golden Boy, the Member of Parliament from Madina, who himself is an astute lawyer, Lawyer Xavier Sosu. You're live on TV3 Ghana. Today is the day. What do we expect going into this vetting?
Good morning to all your cherished viewers. I think that we should expect nothing but the best. There's an opportunity for the committee to interact with the nominee and probe into his professional life, probe into his experience as a lawyer, and having risen himself to the position of a Supreme Court Justice, and interrogate the critical issues of constitutionality, fairness, improvement of the justice system and the judiciary as a whole. So I'm looking forward to a really good session, and Ghanaians can just trust that Parliament will do its work, and I'm sure that the nominee is seized with the knowledge to really deliver.
Talking about constitutionality, fairness, your colleagues on the other side have raised issues over the period. Today we see them here. Maybe let me just ask this way: do you expect their cooperation going into this?
I think that showing up here really shows that the positions that they took earlier, they've advised themselves to abandon that position because they didn't want the vetting to happen at all, because they were citing some potential biases on grounds that some processes have been filed by the former CG. But the Speaker has clarified that point and said that the further processes are pending would not stop Parliament from doing its work. And so I think, I believe that it is out of respect for Speaker's ruling and Speaker's clarification of the points that I'm sure they have shown up here. And we are looking forward that they will do their job as minority, because it is minority that holds, they have a critical role to play in our governance architecture. And so I'm glad that they are here.
Thank you so much.
Pleasure.
Madina Golden Boy, as it were, lawyer and Honorable Francis Xavier Sosu, Member of Parliament for the Madina constituency. I see the chairperson or the chairman of the committee around, which means that any moment from now, the vetting would commence, and what we've all expected would begin, the vetting of the Chief Justice nominee, Paul Baffoe-Bonnie. I have with me a member of the committee, Honorable Mahama Shaibu. Honorable, a simple question goes: what do we expect going into this, and your own expectations as well of the nominee?
I think it would just be the normal vetting. The nominee, we all know, has risen through the ranks to wherever he's been nominated. I don't think there are extraordinary stuff and questions that will put the nominee out of gear. And so this particular one, just testing the competence and affirming the confidence that the president has in reposing it on him. And so I think it's going to be quite a simple one, and we hope to witness a very great vetting.
That's a very great vetting indeed. Thank you. But let me quickly try to pick a word from the minority side, and I'll come back to the majority side indeed. Really, also because they've had a very strong position over the period about the nominee. But let me pick a word from the minority legal representative, John Darko, who happens to be MP for Suame, to see really what they make of the vetting process going into today's activity. And so, as it were,
they will join us. So just wait. I'm not going to say anything.
I'm yet to see the leader himself.
No, leader is around. He's around. Yes.
So he will also be here any moment from now.
Yes. Leader will be here.
Do we expect a long day?
I don't know. So just wait. I know you have a way of eliciting answers, but that's what I'm going to say. I'm not going to say much. Let's just wait. Leader will come, and then the meeting will start. After that, we can have all the conversation.
Thank you. John Dako there.
John Dako is the legal representative for the minority. He speaks for the minority on legal matters. Indeed, even before today, we know very well that the minority has held a good view of what they make of the appointment and their demands thereof, which culminated in a response from the Speaker last Friday, that ruling which the Speaker gave. And so once they are here, it means that we expect to get that cooperation from the minority side. He makes it clear that leader himself, Alexander Feyomaking, is around and very soon should be in this vetting room. Already I've earlier seen the second minority whip, Jerry Ahmed Shaib, also around. I've seen chairman of the committee also come, and a few more members of the committee, and even from the minority side, who are also making their way into the vetting room. Honorable, and so maybe I will seek to get a word from Vice Chair of the committee in the person of Kweku Rekethagan, who is already seated, and it just means that any moment from now the vetting would begin. Let me just try to get some few words from him. Leader, I mean, today is a big day indeed.
Yes.
Vetting of the Chief Justice nominee. I just want to pick your few words. You're live on TV3 Ghana. What do we expect going into this?
Well, thank you very much. I think, this is not the first time we are vetting. This year, remember we did 60 ministerial vetting, and we've done some judges as well. But of course, this is a big one, which is the Chief Justice. I expect things to go smoothly, as the previous ones have, and not learn from our lessons on whatever went wrong in any of the previous ones, so we don't repeat the same mistake and have a smooth vetting.
I mean, the minority heretofore has had a few reservations. We know what happened on the floor on Friday, the Speaker's ruling concerning their motion for this vetting to be suspended. They are here today. We understand their leader is here and should be here pretty shortly. What kind of cooperation are you expecting from them?
Well, Speaker's ruling was the ruling, and that is over. So we are not going to be talking about Speaker's ruling here. I don't expect that. But as you said, they are here. They will be in here. And then we'll follow the procedure and processes and get a vetting done. Okay, thank you.
Thank you. And so I see leadership just walking, leadership from both sides of the House. Honorable Mahama Yariga, who is a majority leader and leader of government business. He himself is here. On the minority side as well, the Chief Whip, Frank Anodompre, is in, as well as the deputies, Habib Idris, as well as Jerry Ahmed Shaib, who have all come to, make this process a very good one. And so, as it were, you have strong representation from both sides of the House. Both sides on the committee are here, including the minority. I want to see if I can get a few words from, just an expectation from leader, the majority leader, just your expectation going into this. Right, he indicates that he would defer that to later, which is okay. So that is it. But you understand that the nominated Chief Justice comes with a wealth of experience indeed, from the Court of Appeal, the High Court, and now to the Supreme Court. It just means that he's had that wealth of experience, and also because even before serving at the court, he has served in various positions, from taxation to serving at the prison service to other places as such. It just means that he's someone who has worked in different or diverse diverse positions or in leadership. And we know currently, and as it were, that even the wife happens to be the director of the prison service, which is a love story that many of you talk about. You know, there is that interesting one about the example cited that if the husband arrests you, the wife will take care of the rest. So all of those are some of the interesting perspectives that this vetting indeed brings. And when you see the kind of support or the representation, as it were, that we have right now, it makes it a good one. You know, it makes it a good one. So let me still try to see if I can get a few reactions from some of the members of the committee, and to see really what they expect going into this. I'll try to see if I can get just some few words from Honorable Tampuli on his expectation going into this day. It's a big day. Words from you. What do you expect in and of yourself going into this?
Oh, the process is about to begin, and I think that just as we've done in the past, it's going to be, you know, the usuals, very civil and very intellectually engaging exercise to bring out the best out of the nominee. As we are vetting him not for the position of a justice of the Supreme Court, but as a Chief Justice. And by reason of that, we are not testing his knowledge of the law. We are looking at his administrative acumen. We are looking at his capability in running the administration of justice and how to manage, plan, organize, control, and discipline. That is what we are looking at. And I think that the exercise will begin shortly.
The session begins shortly. I mean, as we know, your side has had a view over the period. You happen to be here. Many were expecting that you wouldn't even show up at all, but you are here indeed to support this process, which is what defines democracy indeed. We expect your cooperation indeed, isn't it?
Well, like I said, we are here. We raised an objection, we filed a motion on the floor of Parliament. The Speaker said it was inadmissible, and so here we are. So let's see. Let's see, yes. Indeed.
So you're a subject matter rep or a member of the committee? Yeah. Great. Honorable Baffoe, can I get just some few words from you?
Yes, sir.
Today is a big day. Today is a big day.
Yes, sir.
What do we expect from your side going into this vetting?
Perform our constitutional duty. That's all. Perform our constitutional duty.
Yes, which means that we expect you to cooperate really, and you're already here, which is a great start indeed.
You are likely to witness what we are likely to do.
All right. Thank you. Very brief and crisp. We are likely to witness what we are likely to witness. That is a brief understanding that we have from the minority side indeed, that they are ready to perform their constitutional duty. But let me see if I can briefly get Honorable Enyemedu entry. Also because we know that in that motion sent to the Speaker, he was one of the sponsors. And that gets eventually dismissed by the Speaker. Just want to pick his thoughts really. Once being here, it means that he is ready to support this process. And so council, just some few words. Indeed, you're already here. We know that you were part of the 6 members who sponsored the Speaker. Halted until all the pending cases filed by Justice Gertrude Tokono are resolved. That has been dismissed, but you're here.
Oh, it was not even admitted.
Yes.
The motion was not admitted.
Yes, and that is what the Speaker said on Friday.
Yeah, and that's why I'm here. It was not admitted. So there should be an end to any litigation. We put out our case, and if it's either admitted or it's not, and it was not even admitted for us to argue it. So the next thing is that Parliament is vetting the man, and that's why we are here.
And that's why you are here. So yeah. we expect your cooperation indeed.
Of course, otherwise I wouldn't have been here. Yeah, that's why I'm here.
What is your expectation of the nominee himself? I'm sure you've had one working relationship or the other with him. You've known him for some time now.
Teacher, when he was a circuit court judge already, and nobody can fault him on his competence. So I think he's well qualified. There are other questions that we need to pose. to make, because he's going to be the Chief Justice of Ghana. Yes, but his competence, nobody can doubt him. Now, like I said, he was a lawyer before I went to the law school anyway, so I don't doubt his competence. And I take this opportunity to congratulate him, right, personally. Right.
Thank you.
My pleasure.
Thank you so much. So we've been engaging Honorable Kwame Anyumedu-Entry, who has just shared his thought on this process, and indeed the great expectation of that democratic process that we are just about to witness. I'll see if I can get Honorable Boama to just utter some few words, also because he happens to be a member of this committee, and so he carries some weight as well. Honorable, this is a great democratic process that we're about to witness. Vetting of Chief Justice. You are a lawyer yourself. You understand this process and all that goes into it as chairperson of the Subsidiary Legislation Committee. What do you expect, or what should I expect of you?
Thank you very much. This is a process set out by the Constitution, and we are here to do exactly what the Constitution has advised us to do. And it's not the first time that we'll be vetting Chief Justice nominee. We'll go through the motions, ask the right questions. A report will be generated by the committee, sent to plenary, because this is a referral from the Speaker to us. Debate will ensue, and a decision will be taken on the nominee. So that's the process and the procedure that I've set out to you. And we wish the nominee well. Thank you very much.
Thank you. And just a quick one on this. Indeed, many are your position on the So live here on TV3. Now, the Appointments Committee of Parliament will later this morning, as you've just seen a bit of it, vet the Acting Chief Justice nominee, Justice Paul Baffoe-Bonnie. Justice Paul Baffoe-Bonnie's nomination follows the removal of former Chief Justice, Her Ladyship Gertrude Araba Esaba Sakitokono. Now, the vetting will assess the nominee's qualifications, experience, and suitability for the position. Remember that the committee will then present its report to the plenary for consideration. Now, Paul Baffoe-Bonnie was appointed Acting Chief Justice, and that was earlier this year, since April actually, when the then Chief Justice Gertrude Araba Esaba Sakitokono was suspended by the President, and Justice Paul Baffoe-Bonnie is also currently the most senior judge on the Supreme Court bench. He was appointed to the Apex Court in June 2008 by then President John Agyekum Kufuor. He rose through the ranks of the judiciary, serving as a circuit court judge in Kumasi, a high court judge at Duayao in Kwanta, and later as a court of appeals judge before his elevation to the Supreme Court.
And as you've been watching from the live coverage that we gave you, our reporter giving us that update, he was actually speaking to the Member of Parliament for the Okai North, Patrick Boama, and of course we'll be going back to Parliament very shortly. But again, if you're just joining us, this is our coverage of the vetting of the Chief Justice nominee, Justice Paul Baffoe-Bonnie, who is about to face the appointment committee later today. And just a reminder that Justice Paul Baffoe-Bonnie's nomination follows the removal of former Chief Justice. That was in September. Her leadership, Araba Esabasaki Tokonu, the vetting will assess the nominee's qualifications, experience, among others. Now, this is also coming at a time when the minority in Parliament is actually agitating against her removal. Remember that the committee that recommended her removal said that she was being removed for stated misbehavior. And that was after the Council of State was asked to look into the petition that was submitted in March. And then in April, she was suspended whilst investigations were going on. We're showing you live visuals from Parliament's Appointment Committee. And like I did tell you, the Chief Justice, the acting Chief Justice, will be vetted very shortly. Already we've seen a number of Supreme Court and other justices seated already. We've seen Justice Kwaman, who was part of the committee as well, that oversaw the removal of the then Chief Justice Gertrude Araba Esaba Tokonu. A number of MPP MPs as well there who are part of the minority in Parliament. And you saw Christian Yale asking that question of Eyimedu Entry, why the minority said that they were against this vetting, and yet the members are representing, and you heard the answer given there. And also the Member of Parliament for Medina, Xavier Francis Susu, also giving his side of what should be expected today, that is going to be a good one, that would really look into the qualifications of the CJ nominee. And yes, let me remind you that Justice Paul Baffoe-Bonnie was born on the 26th of December 1956. He has had a distinguished career serving in various capacities across Ghana's judicial system, of course, culminating in his appointment as a Justice of the Supreme Court of Ghana 17 years ago, a position he still holds, and now going to be vetted as the overall boss, as it were, the Chief Justice of the Supreme Court of the country. Of course, he previously served as a Justice of the Court of Appeal and High Court and a Circuit Court judge. Before joining the bench in 1992, he worked as a Principal Inspector of Taxes and Head of Legal Eastern and Volta regions at the Internal Revenue Service. That's the IRS. Of course, before then, he was Deputy Superintendent of Prisons and Head of Legal at the Prisons Service Headquarters. A graduate of the University of Ghana and the Ghana School of Law, Justice Paul Baffoe-Bonnie had his secondary education at Konongo Odumasi Secondary School, where he obtained his O and A level certificates. Currently, he chairs the Disciplinary Committee of the General Legal Council, the Election Management Committee of the Judicial Service, and the Finance Committee of the Judicial Service. So you can imagine that he's coming on board with vast experience, and these are some of the things that the members of the Appointment Committee will be looking into. His expertise spans constitutional law, judicial ethics, taxation, prison administration, election law, and legal education, with special emphasis on election and electoral laws. And if you've been following our current affairs and news programs here on TV3, you would recall that the acting CJ, who is going to be vetted today, has been speaking really a lot vociferously about the illegal mining menace. And on Saturday, during the 29th GJ Awards, he gave his voice again and spoke about the menace currently facing the country, that is the Galamsey issue. Let's watch what he said exactly.
Galamsey remains one of the gravest challenges confronting our country. It has destroyed our rivers, poisoned our soil, and displaced communities. But beyond the visible scars on the land, Galamsey represents a deeper wound, a failure of collective responsibility. Your Excellency, ladies and gentlemen, the fight against environmental degradation cannot be waged in silos. It demands a strong partnership between the executives, the legislature, the judiciary, the media, and civil society. Each arm of government and each institution must perform its constitutional role with integrity, accountability, and respect for the rule of law. When the media operates responsibly, with responsibility, the judiciary with impartiality, and the executive with transparency, the foundation of our democracy remains firm.
Chief Justice Paul Baffoe-Bonnie there, speaking on Saturday at the 29th GJ Awards. Let's go back to Parliament. The Appointments Committee, Christian Yale, is on standby to bring us the latest from there.
Voting of the Chief Justice nominee is expected to take place. Currently, the chairperson of the committee is seated. Other members from leadership from both sides of the House, from both the minority and majority, are also seated. Right now, very soon we expect the nominee to enter the room. Once he enters, he takes the oath, and after taking the oath, the process would begin. So that is what is expected, and so all is settled. Indeed, one who we still expect to come is the minority leader, Alexander Feomarken. He has not entered yet, but the indication we have received is that he is going to be here to join the vetting. And so right now you have the minority whip, Jerry Ahmed Shaib. We just saw the chief whip himself, Frank Anodompre, enter, and as well the two other whips are in. So there is only one seat left empty, which is to be filled by the minority leader, Alexander Feomarken. It is one that you really want to look forward to, also looking at all the issues that have come up concerning the nomination ever since the other Chief Justice, Gertrude Tokonu, was removed from office after that investigative work by the Poaman Committee. And right now, we have the minority leader enter. Alexander Feomarken has just entered and is about to take his seat, which means that all is set. Really, we are good to go. And once the nominee is in or has been ushered in, the process would begin. But just like I was about to tell you, Justice Baffoe-Bonnie comes with a wealth of experience, having served in public service for a good period. Right now, he happens to be the senior at the Supreme Court bench. And so when you talk to some of the Supreme Court justices, they make that understanding clear to you that yes, he deserves it. He is the senior most, as you would call it. And so what it means is that he deserves that appointment, albeit made all those, I can see from behind that the nominee is just about to enter the committee room with a team accompanying him. And so there you have it. Justice Paul Baffoe-Bonnie has just entered to an applause. Just as you know, we have a very strong representation from the bench, justices from the Supreme Court who are here to support him. You know that the wife happens to be the director of the prison service, so members and officials from the prison service are also here. And just about now, the meeting has been called to order. We zoom in straight to the vetting prayers. Now we cross over.
Almighty God, we humbly beseech thee to look with favor upon this Parliament of the Republic of Ghana. Grant that it may perform its high duty as in their sight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people may be well and truly served, and their good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people and the love for the common good. Bless the effort of those who struggle to make this vision a living reality. Inspire and strengthen our people that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Amen. Honourable members, may I use the opportunity to welcome all of us to the vetting of my Lord, the Chief Justice to be. Honourable members, following the nomination of the Chief Justice, His Excellency the President of the Republic of Ghana, by a letter dated 17th October 2025, communicated saying to Parliament, honourable members, this was duly referred to the appointment committee to conduct the vetting and report to the House. In view of that, this meeting has been organized. Honourable members, the purpose clearly is to vet His Lordship Justice Baffoe-Bonnie as the Chief Justice of Ghana. Honourable members, he has been vetted and approved by this House as Justice of the Supreme Court of Ghana. He is now being elevated to a leadership level as the Chief Justice. We are therefore here to have him vetted. Honourable members, once again, you are all welcome. Honourable members, as the tradition demands, we shall proceed to call on the clerk to have the Chief Justice sworn in.
I hereby proceed to lead the nominee to take the
Chairman, for the record, honourable members, I believe this proceedings must be orderly. When you have an issue, the practice is that you catch the eye of the speaker, and in this case, the eye of the chairman. You don't have a right to ask anybody to stop proceedings for you to say whatever you want to say. Honorable members, the idea is, why should I refer to him as a Chief Justice but not Chief Justice nominee? Chief Justice nominee, you are welcome.
Let me see.
Honorable Habib, let me hear you.
Chairman, thank you.
I hope it's not different from what I said, Chief Justice.
Close to what you said. Initially, you said the clerk shall swear in the Chief Justice. And this is Parliament, and for the record of Parliament, that will be captured. So if you are correcting it, then direct that your earlier statement should be expunged from the record.
Unfortunately, you don't have a right to tell me what I should do. Once the correction has been made, may we proceed to administer the oath. Clerk of the committee.
I hereby proceed.
I, Paul Baffoe-Bonnie,
Swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue
shall
be the truth,
the
whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Thank you very much. Honourable members, procedurally, I will ask the members of the committee to introduce themselves. It's going to be self-introduction, starting from my left. Honourable members, only members of the committee.
So members.
Nana Ejei Baffoe Ewua, the Honorable Member of Parliament for the good people of Menchia South, and Vice Chairman, the Subsidiary Legislations Committee.
Yes.
Thank you, Mr. Chair. My name is Hassan Tampoli. I'm the Member of Parliament for the good and virtuous people of Gushegu in the Northern Region, and then Deputy Ranking for Constitutional and Legal Affairs Committee of Parliament. Thank you, Mr. Speaker.
Thank you, Mr. Chairman. I'm Honorable Anthony Mie, Member of Parliament for Odotobri in the Ashanti region. I also serve as the Vice Chairman for the Committee on Judiciary. Thank you.
Thank you, Mr. Chairman. My name is Kwame Enyimedwentri, Member of Parliament for Asante Achem Central and a ranking member for Constitutional Legal.
Joseph Frimpong, MP Nkoko, Chairman of the Judicial Committee. Thank you.
Kwame Apiakodua, Member of Parliament for Mfantiakwa North in the Eastern Region. Subject member. Petitions. Petitions and Judiciary, sir. I'm here as a subject matter member. Thank you.
Petitions Committee.
Petitions, and I'm a member of the Petitions and Judiciary, but I'm here in the name of the Judiciary.
The rules are clear in Standing Order 1217. Strictly subject matter committee.
I'm here on the ticket of the
and then leadership of the subject matter committee. So you are either a chairman, vice chairman, ranking, or deputy ranking of the committee. Honourable members, let me use the opportunity to clarify Standing Order 217. We do not want any confusion. If you know you are not a ranking member, deputy ranking, chairman, and Vice Chairman of the Subject Matter Committee, please perpetually remain silent.
Thank you very much, Chair Patrick Boamo, Kankwe Central, member of the committee.
Jerry Ahmed Shaib, MP for Wejagbawe, leadership.
Alhaji Habib Idris, Member of Parliament for Tolong, First Deputy Minority Whip, Member of the committee.
Honor Dompre Nsauma Reggie, Minority Whip.
Yes, now on my right.
Thank you very much, Chair. My name is Bede Anwatasmo Sieden. I am the MP for Laura and ranking for Judiciary, Subject Matter Representative.
Al Hassan Umar, MP for Zabzugu in the Northern Region, a member of the Appointment Committee.
Thank you, Chairman. My name is Shaibu Mahama, MP for Daboya Mankargo, Chairman for Constitutional and Legal Affairs Committee of Parliament, and a member of the committee.
Thank you, Chairman. MP for Adan Leadership. Thank you.
Ladi Ayayamba is my name, MP for Pusiga, ranking for Chieftaincy and Culture, and a member of the Appointments Committee.
Chairman, thank you. CJ Nominee, you're welcome. My name is Roxanne Nelson Dafamapo, MP for the good people of Southline, member.
My name is Mahama Ayariga, Member of Parliament, Boku Central Constituency, leadership.
Thank you. My name is Kweku Ricketts Hagen, Member of Parliament for Cape Coast South and the Vice Chairman of the committee. That's the Appointment Committee. Thank you.
Afenyo Makin, MP for Efutu and ranking for the committee.
Bernard Ahiafo, Chairman of the Appointment Committee. People also call me the Kingmaker. So, honourable members, commencement. Yes, I see you pulling the microphone. Do you have an issue?
Chairman, with respect, thank you for the opportunity, and I shall proceed with my opening remarks, which remarks I make for and on behalf of the Minority Caucus of this committee.
Honorable Minority Leader and the ranking member of the committee, I shall accord you every respect and the time to raise your issue. My only hope and prayer is that whatever issue that you are going to raise must be raised within the rules that governs this committee as well as the entire Parliament. The floor is now yours.
Chairman, thank you very much. I shall proceed my remarks with a quote from Shakespeare's Macbeth, Act 1, Scene 7. First,
as I'm his kinsman and his subject, strong both against the deed, and as his host, who should against his murderer shut the door and not bear the knife myself. Besides, this Duncan has borne his faculties so meek, has been so clear in his great office, and his virtues will plead like angels, trumpet-tongued against the deep damnation of his taking off, and pity like a naked newborn baby, striding the blasts of heaven's cherubim, housed upon the sightless couriers of the air, shall blow the horrid deed in every eye. Tears shall drown the wind. I have no spare to prick the size of my intent, but only vaulting ambition, which overleaps itself and falls on the other. Chairman, this morning, on behalf of the caucus, we hear with a heavy heart, but an unshakable resolve to defend the Constitution of Ghana, protect judicial independence, and uphold the rule of law. We gather to vet a disputed nominee for office of Chief Justice of Ghana. This should be a moment of national pride and institutional renewal.
I have an issue.
Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control.
Honorable Minority Leader. Honorable Minority Leader, just hold it a second. Yes, Honorable Ayariga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we gather here. Order 122 and 123. I want you to focus on those two orders. 123 talks about content of speeches, whereas 122 provides the grounds on which debate can be interrupted. So I come under order 122. But my objection is founded on content of speeches. I've heard the ranking member of the committee refer to, I believe, the nominee as a disputed nominee to the post of Chief Justice. 123 says, a member shall not raise any question. 123(5). A member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. I recall that just a couple of days ago, I think Thursday, the same member brought a motion to the House trying to stop this committee from sitting to vet the nominee. The matter was exhaustively debated, and you, Mr. Speaker, gave a ruling. Subsequently, the Speaker himself, because you sat as a Deputy Speaker, the Speaker himself came and recounted the motion and also gave a ruling. So this issue about the propriety or otherwise of whatever happened has been raised on the floor, debated extensively, and a ruling given. Apart from that, Order 1237 1237 says that the conduct of the speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Judicature of this country in Parliament except by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody, and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object. So I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
Yes, Honorable Habib. There is an issue raised.
Yes, that's what I'm...
And I must give the floor first to the person who raised the issue in relation to which objection is being taken to respond. Yes, Honorable Minority Leader and the ranking member of the committee. This is the issue raised to part of the submission that we have started raising. What is your response to it?
Chairman, first of all, the majority leader is clearly acting in bad faith, seeking to obstruct the rather peaceful processes we have started, and as it were, try to use his numbers to intimidate. Let me ask, the rule he relied on has to do with debate on the floor of the House. There are dark clouds indeed in this country where freedom of speech by mere operation of a supermajority, you cannot even as a member of parliament make your comment. I am not moving a motion. I am not debating. Please, Chairman, the rule he relied upon. Is it this situation where people move from here and there to create confusion and create their own jurisprudence must come to an end with respect. Interruption of debate. That is, if you go to page 70 or the 122, the title there, the subtitle, interruption of debate. Debate may be interrupted by a point of order. And then he says that I am debating. Who is debating here? Mr. Chairman, if the majority leader has anything to say in opposition to my opening remarks, he has a right bona fide as a leader of government business and as a leader of the House to also state his submission. I have seen him with his written submission, be it for his opening remarks or see that to you as a chair of the committee to read it for Hansard. But this process where, as it were, try to use it to deny you, don't say this. So every line that I read, he will censor it and say, you use this word. Mr. Chairman, we are not going to make any progress with that. Again, the 1, 2, 3 that he relies upon. It says that the conduct of the Speaker, the Chief Justice, members and Justice of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. With the greatest respect, have I raised any issue that is situated within the context of 123(7) to warrant this so-called objection? Chairman,
Honorable members, can we have some order?
Chairman,
honorable members, can we have some order and listen to the minority leader in silence?
Chairman, we are here to discharge a civic duty and responsibility. We are political actors who have our political views on matters of national interest. The matters giving rise to the nomination is purely political, and every Ghanaian adult knows this. Your side raised it as a political issue during the campaign. You are going to remove Justice Tokonu as Chief Justice, and that has happened. If in my statement I contextualize to say that disputed nominee, it is our view we hold as a minority caucus. Right, expressing. We have to express it. And that is why I added by saying that this should be a moment of national pride and institutional renewal. Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control. Can't I have these bona fides also that have to be obstructed by the majority leader when you have every unfettered right to raise your issues? Chairman, humbly, please control proceedings. Please take charge. Let our respected leader of government business understand that after speaking, after making my comment known on behalf of the minority, he can seek your leave to also make his opening remarks. By the way, by way of conclusion, this is not the first time a leader in the minority is having this opportunity to make opening remarks. It predates me from J.H. Mensah's era, he and J.H. Owusu Achampong, all the way to Alban Bagbin, MP for Naudole Kalio, and minority leader as he then was. The videos are there. Hansard is there. The Honorable Bagbin had unfettered opportunity to make his political statement on behalf of the minority, and they were not stopped on point of order. It got to Chair Mensah Bonsu, it got to Harun Edrusu, and recently, my own respected colleague, Dr. Kasiel Atufosen. The records are there. Let's not create a certain impression as if all it is you are majority, so we cannot even say a word. We must have our rights. These are far right. We will state them, and you would also have the opportunity to state them for the record. Please, let us have some more.
Honorable Minority Leader, your point is made. Yes, you have listened to the response.
Right,
Honorable members, it's not every issue that will necessarily call for the chair making a ruling. But honorable members, I indicated as a preliminary issue that let us all operate within the rules. Honorable members, may I add that we need to also observe the principle of brevity. Yes, what do you have to say?
Chairman, if you read rule 1233, where in the opinion of the Speaker, the words of a member used in a speech, and it doesn't matter whether the speech is at plenary or at committee, a speech is a speech in Parliament. So where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. Mr. Speaker, when we came into this chamber, this committee meeting room, and you started, you referred to the nominee as Chief Justice. When you refer to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also an acting Chief Justice. And an acting Chief Justice is a Chief Justice. Now, he has referred to the nominee as a disputed nominee. Disputed nominee. Disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination. If there is a dispute about some other action. So you have no right to look him in the face here before this committee and refer to him as a disputed nominee and expect me to sit here and not respond. So, Mr. Chairman, pursuant to our own rules, he has to withdraw and apologize to him for referring to him as a disputed nominee when he is not a disputed nominee.
Chairman, let me.
Honourable members.
Chairman, he has had two opportunities to make a point. Let me respond to
Honourable members, Honourable Minority Leader, listen to what I will have to say.
Okay.
Please proceed and raise your issue. Avoid the use of disputed Chief Justice. Once I do not have a right to refer to him as a Chief Justice, but Chief Justice nominee. Let us all observe that rule and refer to him as such.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
I object again. I object again.
On the 22nd
I object again.
April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
Hold on. Honourable members, I think at this particular point, I must place on record that I have admonished that we should all operate within the ambit of the law. Honourable Minority Leader, be guided by Order 103D, and then let's make progress. And Order 103D, if I may read, to serve as a guide to all of us. It states that a motion shall relate to a definite issue and not revive the consideration of a matter which had been considered in the same meeting unless new matters have arisen. Honourable members, by necessary implication, whether a motion or not, the principles of res judicata will not permit us that a matter that has been raised on the floor resolve to its finality would be permitted to be raised at a committee meeting. So, Honourable Minority Leader, refrain from anything that is relating to sub judice rules and let's make progress, with all due respect. Because Speaker has dealt with this matter. I have also personally dealt partly with this particular matter, with all due respect.
Chairman, the facts speak for themselves. On April 22nd, 2025, Chief Justice Gertrude Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship Gabriel Scott Poama to trial the Chief Justice amounted to a travesty of justice.
Chairman.
The removal
our rules are clearly offended.
In the language
our rules are
of
clearly
judicial
offended.
accountability.
Because the rules I just read clearly offend that.
But
the rules clearly are offended. Chairman, the rules say that the conduct of the speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Chairman, let me respond to him.
You see, I cannot go and be giving you the opportunity when the person who is speaking is in the process of responding to the issue.
It doesn't fit in the rules.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman.
Honourable members, order. Honourable Oman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to.
Yes, before I address, I've made an observation. The learned Attorney General knows how much I respect him. He knows how much I respect him. And this must be reciprocated by him. When the respected learned Mahama Yariga, leader of government business, was raising his objection, I remained quiet to listen to him because I know that decency requires that we listen to each other in silence. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the majority leader. Chairman, it is his contention that my reference to the committee's work amount to attacking the conduct of its chair. with the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view that the committee's work resulting in the removal of Her Ladyship, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend Order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament except a substantive motion. Now, the distinction must be made. Respected Ayarga, please bear with me. I've listened to you. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal conduct that one would consider as misbehavior or stated misbehavior. I am not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't attack him. The caucus is talking about, please, Honorable Ayarga, let me finish. You were allowed to make your point.
Yes, but Honorable Minority Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed.
That's very important, Chairman.
Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? When you have the right to say your own, you are the leader of the House, you have unfettered right to rebut. That is the debate we even have on the floor. When there's a debate, you take note. Where you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. We,
Honorable Minority Leader, kindly conclude for me.
The work of even
Please conclude for me. Conclude for me.
I beg you, leader.
Conclude.
We all agreed, Chairman.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority leader.
Travesty of justice is now.
I have listened to the
minority
leader. Honorable members, we should be guided by the principles that if there is an issue on the floor of Parliament which has got to do with another who may not have the opportunity to respond to it, such a thing should not be made on the floor. Now, though Justice Gabriel Poma is here in person, at no point will he have the opportunity of responding to any issue raised about him. None of the committee members will have the opportunity here and then to make comment. Therefore, for you jumping into a conclusion to say that their reports amount to a travesty of justice without any of them having the opportunity to respond offends our rules, I will consequently order that anything in relating to the committee and Justice Poma should be expunged from our record. That is my ruling.
Chairman,
Kindly proceed.
Chairman, let me protest the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That said, I will proceed.
Yeah.
We hold a view that the removal of Her Ladyship Justice Gertrude Araba Isaba Tokonu was cloaked in some opaque circumstances unacceptable to the jurisprudence of our country.
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable Minority Leader, you know the rudiment of the game. If you don't want interruptions, let's go by the rules. Other than that, the chairman will be compelled to listen to the person and make ruling.
This one is friendly. Opaque. It's friendly. Opaque.
Yes, Majority Leader.
Mr. Chairman, Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. Freedom of speech. But before this Committee of Parliament, the rules are clear. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this Parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did he say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, a travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honourable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I would order that same be expunged from the record as if it doesn't exist. Honourable Minority Leader, proceed.
Chairman, with respect. Chairman, with respect, he raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honorable Minority Leader, kindly proceed.
It is our contention that the process leading to the removal of Her Ladyship Justice Araba Isaba Tokonu was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman,
we continue.
I hope, Chairman,
to say.
I hope, Chairman, that persistently violating the rules of this House is a breach of privilege. You know that. Persistently violating the rules of this House.
Chairman, Honorable
Minority Leader.
He's made a point. Let me make a point with respect to you.
Honorable Minority Leader, if you can hear me out, yes, maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is. So I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect.
Honorable Tampuli.
Mr. Chairman, thank you.
In this House, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us.
Speaker,
so I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is re-litigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And it is the view of the minority. And I think that it should be allowed to land. Then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker. Thank you, Mr.
Honorable Tampoli, if you want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampoli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5, with respect, Mr. Speaker. Order
Yes.
5.1, subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2, in any case not provided for in these orders, Mr. Speaker shall decide on a procedural question. And finally, 3, in exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing,
yes,
it may not be provided for expressly.
No, but so what you are saying,
what you are doing amounts to being guided by Order 5.
Rules, yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution, under
so you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say the Parliament. So, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to land. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule against, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24 B and D. Mr. Speaker, with your permission, I read Order 24 B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24 D have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker.
Thank you.
Honorable Minority Deputy Whip, it is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the right of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman, and keep to the rules because I will object to anything that violates the rules.
But when we do this, it's not okay.
Mr. Chairman,
Minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions. Our own Supreme Court, the High Court, and the ECOWAS Court of Justice now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain pending,
Mr. Chairman,
while the very question of whether a vacancy exists remains subject, there is a nomination
I object.
Leader, one microphone should be off so that I can have the floor.
Araba is about to.
Honorable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from random commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this house, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are a your marking. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afanyo Makin, have a right to make preliminary statements. You don't. We developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away once I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
I have his, at least if I catch you.
It gives you the opportunity because he is on the floor. Tell him, when he said I should hear Tampuli, I heard Tampuli. Should I hear another umbre? Should I hear another umbre?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodumbre, what do you have to say on the issue raised by the majority
Speaker,
leader, Honorable Mahama Yarga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised at some of the issues being raised by the majority leader, saying that show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show me the rules that tells us that every Friday you should be standing behind the dispatch box and be presenting petition. There are no rules on that. But it's part of our practice. And majority leader, with respect to you, know this. So don't keep referencing that, saying that show us the rules, show us the rules. It's not just about the rules. It is also about our practice. Now, the very rule you referred to, 103, when you said it could be applied mutatis mutandi, I think majority leader, you are wrong. The rules were made with specific functionality, and the 103 you quoted is on admissibility of motion. No, it's motion. And it's giving us conditions for admissibility of motion. So when you read the heading, so you are interpreting the rule to suit your understanding. A while ago, Tampuri just referenced Order 5 and says that interpretation will be done by the speaker. Allow the speaker to lead the process. Allow the speaker, the chair, to lead the process. All of us are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong impression, and the public is watching. You will not even allow the minority leader to speak. And you are marking every sentence, and we are here saying that is normal. Why don't you take your note? When he's done, then you can present your version of the truth.
His law teacher started marking his sentences long ago. I'm not the first person to mark his sentences. His law lecturers marked his sentences for years.
Anytime it appears to me, I'll conclude. Because you are pushing me to conclude, I'll conclude. But interestingly, the majority leader catches your eye every time. It is surprising that he always catches your eye. When we also draw your attention, let us also catch your eye. We also have something to say. Parliament is not just about the majority leader. For heaven's sake, I'm representing the good people of Insama Dreji. And when I have a view and I catch your eye, you must allow me to express him. I want to tell the majority leader, anytime he obstructs the minority leader, we will also obstruct him. No? Let him make his point. If it is the case that your strategy is that you are going to obstruct him, we will also obstruct you. And you won't make your point. But the begging question is, to what end? Are we going to conclude this vetting? What are we telling Ghanaians as representatives of the people? Speaker, I think you should rule on this matter. The majority leader should put down his points. Can I finish? For heaven's sake, can I finish? The respected majority leader I saw him taking copious notes. He should write down his points. And regardless of the fact that he's a majority, he's a member of parliament like anybody else. Let him write down his points. When the minority leader is done, then he can come in. Then we can make progress.
This whole strategy of any sentence.
I would have been asking questions,
It's not going to
but
happen.
sometimes when I ask questions, they take it that I'm being sarcastic. I will give the floor to Honorable Roxanne Dafamoko.
Chairman, thank you for the opportunity. Chairman, given where we are, I seek your guidance on this matter. And here it is. Within the terms of Order 103, Rule D, Rule E, and F, the minority leader led a team of his members. They filed a motion. The terms of the motion, Mr. Chairman, reads as follows: that this honorable House, having regard to Articles 110, Clause 1, 125 to 127, 144, Clause 1, and 146 of the 1992 Constitution and Standing Orders 57, Rules 1 to 3, Order 93.
Is that the motion Speaker rule on?
Yes. For the records, I'm reading the terms of the motion they filed. Yes. Order 103, Rule F, Order 216, and Order 217 of our standing orders resolves to suspend forthwith all further proceedings, both at the Appointments Committee and our plenary, on the nomination of Justice Paul Baffoe-Bonnie as Chief Justice until all pending suits and applications directly bearing on the removal of a leadership Justice Gertrude Araba Isaba Tokonu, Saki Tokonu, including ECOWAS Court, suit number ECW/CCJ/APP/32/25 on provisional measures, multiple Supreme Court proceedings, and High Court applications are finally determined or withdrawn, and that in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination, and that the Attorney General and Minister for Justice be summoned pursuant to Article 103 of the Constitution to appear before this House or before such committee as the House may designate, to provide a comprehensive briefing on the status of all pending litigation relating to the removal of a leadership Justice Gertrude Araba Isaba Saki Tokonu, including but not limited to A, the identity, jurisdiction, and procedural status of all such proceedings; B, any provisional measures, interim orders, or conservatory orders sought or granted; C, the relief sought in each proceeding and their potential implications for the office of Chief Justice; D, Ghana's international obligations under regional treaties relevant to the ECOWAS Court proceedings; E, the government's assessment of potential legal and constitutional implications of proceeding with the appointment of a successor Chief Justice while such litigation remains pending; and F, any other matters relevant to Parliament's informed exercise of its constitutional functions under Article 1141. Applicants of the motion.
Well, hold on. Let me hear you, Honorable Habib. What are you objecting to?
Chairman, Parliament and parliamentary proceedings and practices. A member is not to address the House. What Honorable Roxanne is doing is addressing us. Whatever he's reading, Mr. Chairman.
Honorable,
Mr. Chairman, but
you are completely out of order.
To us, Mr. Speaker.
You are completely out of order.
So, Chairman, no, he should stop.
It is only when a supplementary question is being asked.
A motion that the Speaker has ruled.
Would you listen to me, Honorable Habib?
On the floor.
Would you listen to me? It is only when a supplementary question is being asked that you don't address the House. So you are completely out of order. Honorable Minority Leader, May I have your response?
Chairman, I'm not done.
Okay,
I'm
hold
not
on.
done.
Then conclude.
Yes.
Conclude.
No, I'm not done.
Then conclude.
So, Mr. Chairman, these were the terms of the motion the minority leader and his group filed. In the course of considering admitting this motion, Speaker determined that the motion cannot be admitted. Now, the minority leader, as ranking member of this committee, is using a backdoor approach. He has rehashed the terms of this motion contained in a speech, and he seeks to read that speech before this committee.
Member,
it cannot be done.
You've made your point. Yes, minority leader, let me hear you.
Chairman, with respect, thank you for the opportunity. Let me first respond to the issue raised by the respected majority leader, which issue he anchored on Order 103F. For the avoidance of doubt, I would repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with emotion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters
Honorable
have not been dealt with.
Minority
Let
Leader.
me finish.
With all due
Chairman,
respect.
You allowed
Hold on.
the minority leader. I'm
I'm
responding
not
to his
asking
objection.
the minority leader to raise an issue. Order.
I am responding to I'm responding.
Honorable
Let me
minority
respond.
leader.
Let me respond.
Honorable minority
Let me
leader,
respond
hold
to
it.
him.
Honorable minority leader, hold it. May your microphone be off, minority leader.
Chairman, just a second. Bear with
Minority
me.
leader,
Chairman.
let your microphone be off. Hear me out.
Very well. I will hear you.
Yes, I'm
and then
supposed
continue my
to
argument.
play the fair
No, you cannot.
game here.
If you make your point, we respond.
Honorable minority leader,
What is wrong?
please, please,
I
just
don't have to
observe
respond.
me.
The Flame spoke.
Hear what I will want to say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not.
You've said that. You've said that. You've said that. You've said that. You said that. You said that the nominee swiftly empaneled the court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman. No.
I have the floor. You've not called.
Chairman, the rules.
You have not called.
The rules.
Chairman,
The
you see,
rules.
he puts on the
The rules.
Chairman, he puts on the rules.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear. Chairman, the rules. So when you just comes in.
But you just put on your microphone and speak.
Honorable
Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take notes. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement. If we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the hub. on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it.
Okay,
Not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament. This vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee, because for me, that matter procedurally and legally is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response.
No, you see, when your leader is speaking, you're asking me to give you the floor.
The majority leader has raised this issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the majority chief whip. The majority chief whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch the attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the first Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the majority chief whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the majority leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esaba Tokonu has rights, far rights. And what becomes of her when eventually the court determines that all her beliefs are upheld, and then what becomes of us?
Yes, Honorable Majority Leader. Honorable Majority Leader.
You are hearing?
No, I am the one speaking.
What do you want?
You understand? Yes. Please, let's take a cue. Severally,
he has raised it.
I admonished
him or me
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So, minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them Sunday. All that is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt.
What is the problem?
They are in majority, no doubt.
This is a preliminary,
but they should allow us. I'm responding to you. See, Chairman,
to the issue, but you can't be jumping from this issue.
Chairman, what the majority leader is doing, is not fair. He raises his issues. You don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Because
Honorable members, order.
When you are talking,
order.
When you are talking,
honorable members,
talk about the
on this note, we will break for cocoa. So it's time for cocoa break.
So live here on TV3, and quite an interesting debate from the Appointments Committee, where the Chief Justice nominee, Paul Baffoe-Bonnie, has been seated for over an hour, and yet no questions just as yet have been posed to him by any members of the Appointments Committee. Simply put, there's been a spar between the minority leader and the majority leader about the latter's address, or the former, I should say, the former's address. That is Alexander Afenyo-Markin's address before proceedings can officially start. It started off with a prayer which was by the chair of the Appointments Committee, Bernard Ahiafo, after which the minority leader asked that he be afforded the opportunity to make some preliminary remarks with respect to what is expected to happen today. And in that remark, he has, amongst many other things, sought to raise their objections, which formed a part of a motion which was tabled in the House on Friday, that which became a subject of some debate as well, and there was a ruling on. That motion contained their objection to the sitting of the Appointments Committee to consider the nomination of Justice Paul Baffoe-Bonnie, who, by the way, is the acting Chief Justice, has been for quite some time and was subsequently nominated by the President in September of this year. They said that considering there are pending legal issues, one in the ECOWAS court, one before the, or two before the High Court, and then a number of them pending before the Supreme Court, it will best be advised if the House did not consider the vetting of Justice Paul Baffoe-Bonnie until the determination of the matters. And you're seeing the House has taken that, we do not know how long, that cocoa break which the chair of the Appointments Committee has so rightly alluded to, and there are hearty conversations to and fro. We see the chair of the Defense and Interior Committee, James Agalga, and some conversations with some other individuals, and a host of the dignitaries. I see the Attorney General, Dr. Dominic Ayeni, as well, present. He's a former GBA president, if I'm not mistaken, as well, there, and very present, as all of the judiciary really have come to the fore with respect to what is expected to happen today. But I was just walking us through what has been a haggle of some sort over the last hour, and we'll get onto the phone lines as well and engage Zoom, rather, I understand, and engage Christian Maham-Hesse shortly on what it is that we've seen play out. But that concern has played out again on the floor of the House, and the minority are seeking to raise the objection, much to the chagrin of the majority leader, who says that on his watch today, he will not allow the minority leader, Alexander Afenyo-Markin, violate the rules. And by violating the rules, he's of the opinion that the commentary by the minority leader seeks to impugn the work of that Article 146 committee, as was chaired by Justice Paul Scott Poiman, and so will not allow that to hold. And we've been having interjections, counter-interjections, rulings by the chair of the committee, and that's what has persisted up until this break was taken, and reason for which no questions just as yet have been posed at this particular juncture, and we will seek to get a bit more right now from Christian Maham-Hesse, who's a private legal practitioner. Counsel, I appreciate you speaking to us this afternoon, and I'm sure watching from home, the entire process has been quite long drawn. What would be your expectation of the chair of the committee in having us make progress in what it is that we're seeing play out?
Thank you.
Counsel, I don't know if there's a problem with your mic or we have to do it. If you could unmute for us, and then perhaps we can hear you.
It is not muted. Can you hear me?
Yes, I can hear you. It's a bit faint, but let's try and proceed, and let's see if there's progress made.
Yes, what I'm basically saying is that, I mean, it's quite interesting, the wrangling between the two. I mean, it has been a very protracted one. But my humble view is, indeed, I mean, it definitely should be one of balanced rights. So, I mean, just as the rules of parliament has been referred to countlessly from both sides, I mean, it stands to test to say that, indeed, in as much as the honorable minority leader would express his plenary remarks, definitely there's a concession that, and that concession is even hinged in his own speech, that he has not sinned against any third party, whether committee, whether the nominee, and all of that. That alone indicates that there is an understanding that the conduct of the committee cannot be referred to, or its integrity in terms of work can also not be impeached, because that committee will definitely not have the opportunity to respond to same.
Right.
And even though Justice Kwama is present there, legally speaking, he is not present before the committee to respond to such matters. And it stands to say that if the language moderation will do, then we will not have the majority leader, coming in with most of the interjections, because the interjections that he brings into are mostly hinged on the rules of Parliament. So definitely, there must be a management in terms of the language put out there, so that while it is a balance of language which does not affect the rules or impede on any of the rules, it will now favor the vetting to come off, smoothly.
But to the extent that he has persisted in wanting to make that point and make it forcefully, and that has drawn all of this back and forth and has even brought about this postpone, this break, if I can call it that, this break which has been taken by the chair. The nominee continues to sit, and all of the countries is watching. What will be your expectation of the chair? A conversation with the two on this break to have us return, and then the work of the committee proceeds?
Yes, I believe that leadership will go into conclave, and they would have a short or brief deliberation on the way forward, because this spectacle cannot continue going unabated. The more it continues in that direction, it gives a different impression to the general public and the world watching. So definitely, I am of the opinion that they'll go into conclave and leadership will address these matters,
right?
So that when they resume, there would be that brief remark that the honorable minority leader has decided to put out there would be in the moderation of language, so not to sin against any of the rules, for us to have this setting on TV.
And just lastly, on some of the use of the words, not trying to get into the rules of Parliament and the various rules the majority has been using to seek to prevent him from proceeding with these comments. Some of the descriptive words have been expunged, but to others, they are seeking to make a point, and they've successfully made it, whether or not the commentaries by the minority has been expunged from proceedings or the Hansa.
Yes, it is very clear that the minority is bent on letting the whole world know that the Chief Justice was taken out unfairly. So, in such legal proceedings, one cannot hazard what is on the mind of one, as it was said by Shakespeare in Macbeth, that you cannot find the mind's construction in the face. So, it would only come by way of objection and then a ruling by the chair, or as it is the speaker, and that would have it expunged. So before that happens, the world knows what he had already said. Even though properly so, or it will not be in printable language in the records of Parliament. And that's why I'm saying that, I mean, when they are on recess, conclave will definitely meet with leadership and come else so that this wrangling would end for an adopted procedure based upon the leader's remarks, so that we can now go into the vetting proper.
Council, I'll hold you here and connect with my colleague Christian Yale, who's in the committee room for us, get an understanding as to what the conversations are right now following that cocoa break as taken by the chair of the Appointments Committee. Christian, quite a lot of conversations being struck by different persons amongst each other as they await the return of the Appointments Committee. If you've been eavesdropping, talk to us about what they've been saying.
All right, and so currently leadership more or less is going into conclave to decide few things, and then they will be back to resume the vetting. What I can say right now is that as you see in your shot over there, there is the chairperson of the committee, Bernard Ahiafo, who is engaging some members of the committee, even on the minority side as well. You also see the Attorney General, Dr. Ayeni, in that shot as well. Basically, we've had like almost a 2-hour stalemate since the meeting was called to order. It all started with the minority leaders want to make some preliminary remarks, in which he referred to or described the nominee as a disputed nominee. That was where the objection started from, with the majority leader re-emphasizing over and over again that so far as he is around, he wouldn't allow the minority leader to offend any of the rules concerning this vetting process. There he goes ahead to quote a number of the standing orders as well as what the Constitution says concerning gatherings like this and what Parliament does. It's been a back and forth over the period, a long stalemate which has culminated into this break which has been called by chairperson of the committee. And indeed, apart from the use of disputed nominee, we know also that the minority leader described the appointment of Paul Baffoe-Bonnie as political, which is one also that drew some reactions and criticisms as well. Beyond that, the minority leader has sought to, in his preliminary remark, more or less describe the work of the Puaman Committee as a travesty of justice. All of these have been objected to by the majority leader, who says he's not going to, supervise any of such to happen. I have with me the Member of Parliament for Guan, Fred Agbenyo, who has been monitoring the proceedings over the period. What do you make of all that has transpired so far?
Well, it's expected of us as members of Parliament to be disciplined and do things right. Nobody comes here to do theatrics or to prove to the world that he's the best. He's the only person who can challenge and speak and talk and scream and shout. We are all here as members of Parliament in our own rights. Right from the word go, you have disagreed with the process because you thought that your darling girl has been removed from office as the Chief Justice.
What do you mean by darling girl? That is like a claim which I should ask you to substantiate. You may not be able to substantiate. What do you mean by that?
Well, I don't need to struggle to explain or to substantiate the point. That's the woman that she has always stood by. She believed that the woman should have remained in office. She has challenged him in court, and that's why I've chosen to describe her as a darling girl. And she thinks that because I've removed a darling girl, that he can go to court and go and file a case. And within 5 minutes, the same Supreme Court Chief Justice will panic people to listen to that case. And because he wants somebody who will be doing his bidding for him, because that person has been removed so hurt and so pain, he's sitting down here and doing this. And we are not here to do his bidding. We are going to vet the Chief Justice, and Jesus is going to take the office. If they don't want to be part of it, they can walk out. Nobody is forcing them to be here. They can walk out.
Which wouldn't help or augur well for democracy, as we call it. And talking about the concerns that he has raised, like one would say, democracy is about opposition. Over the period, they've had all of these reservations, which resulted in the motion which the Speaker did not admit and subsequently dismissed. Isn't it right, if he wants to air his views using this platform?
Our laws are very clear. You can't come here and accuse Supreme Court justices when they are not here. They don't have the right to rebut or to refute the claim that you are making. They are not here. They don't have the opportunity to respond. So why do you raise it here? Almost all the concerns that he's raising here today are concerns that he raised in the chamber already. So what is new? Why the theatrics? To prove to the people of this country you are the person who can speak most, or you are the one who is more intelligent, who understands the issues better than everybody else. Is that what it is? No, it is not a contest of ideas and people who can speak loudly and challenge every situation. And I think that I want to commend the leader of the House, at least, that he has put his feet there and made sure the right thing will be done. And as I said, they can choose to remain. If right from the word go, they said they were going to boycott the process. I'm even surprised to see them here this morning. I would have thought that they would be in the House and allow the process to go on. But whatever be the case, at West will work out and the process will continue.
So now there is a break, which is expected that very soon the meeting would be called back to session. What do you expect from there?
Well, I'm very sure that as soon as they return, the chairman of the committee will put his feet down and make sure that the process will continue. We will not allow anybody to overindulge and waste anybody's time. We will continue, we will ask the relevant questions of a Chief Justice, and once he has answered the questions appropriately, I'm sure we'll go through the process and get him allowed to take over office.
Thank you so much. So I have been engaging the Member of Parliament for Guan, Fred Agbenyo, who has, among many other things, aired his views on what has transpired so far at this committee hearing. Indeed, we are currently on break. We are coming to you live from Parliament House, the committee rooms 1 and 2, where the vetting of the Chief Justice nominee, Paul Baffoe-Bonnie, is happening. Indeed, we are on break. Very soon, the meeting will be called back to session, but I'm just also trying to see if I can get some few words from the Vice Chair of the committee, really, to know what it makes of what has transpired. Indeed, I engaged him earlier, even before the hearing has started. He was expecting that things would go as smoothly as possible. That did not turn out to be the case. We've had a stalemate. Honorable, earlier when I engaged you, you were expecting or anticipating that this hearing goes on as smoothly as possible. That has not been the case. We've had a long stalemate.
Yes. It's unfortunate. It's unfortunate that we've descended to this point. But I hope that when we get back, we'll be able to put issues back, and straighten things. This is not how it should be. I mean, look, remarks is supposed to be about 5-10 minutes. We don't give remarks all day. If we give remarks all day, how can we, proceed to do things? So I hope that minority leader will be spoken, to make sure that he keeps the remarks short and we finish with the remarks so we can carry on. The unfortunate thing is that the nominee has been sitting here for over an hour and not a single question has been, asked. And that's not fair. And then, if you look at among the guests, there are people who look elderly, who might have to eat, take medication. We should take all these things into consideration and not just be thinking about ourselves and just sit here. So I hope that things will get better. I'm sorry, unfortunately, this is not what I was expecting this morning, but it's I mean, when you say something that is contentious, you invite the majority leader to come in. That's something that we should know. You're not going to sit down and take it, So we should avoid those things, especially things that the ruling had already been given in the chamber, not to be brought here as something new that is being.
Thank you so much. So that is the Vice Chairman of the Appointment Committee, George Kweku Ricketts-Hagan, who has expressed his views on what has happened. He is very sorry about all that has transpired so far here concerning this vetting. And like I indicated earlier, he had anticipated something smoother than what has happened now. Unfortunately, that has not been the case. And so he's just hoping that when the meeting or the session is called to order and is brought back in session, things would go as smoothly as possible. And indeed, you see all these distinguished persons who are still seated and are waiting for the meeting to be called back to order so that things can begin. And indeed, what is also expected is that from the resumption, things would be fast-tracked so that at least the questioning period, which is the main reason for which all have gathered here, would continue. So you see members of parliament, some of them are having some pretty chats with some of the judges who have gathered here. Let me still engage you, Honorable Francis Xavier. So I engaged you earlier. The expectation or anticipation was that this goes on as smoothly as it were. What are your observations so far?
Well, I think that my observations are that the posturing of the minority so far looks like a posturing or a deliberate attempt to obstruct the process. And I say deliberate attempt to obstruct the process because almost every single issue that the minority leader is raising now are issues that have come to plenary, it's been debated, and Speaker has made pronouncements on those things. And so it's quite cunning that the minority leader would want to use this platform as a backdoor approach to reintroduce those issues. And for me, it's completely unacceptable, especially when what you are saying impugns people's character, impugns people's integrity, and so on and so forth. But they will not ever have the chance to respond to those things right there at the committee meeting.
When we say that these are issues they've raised over the period, addressed press conferences and raised these issues, especially concerning the Puaman committee, which he sought to raise again here. What is new about them?
So the question is that why do you want to relitigate it? You know, that should rather be the question. If these are issues you raised already during press conferences, why do you want to raise them in a formal proceeding? I know what they intend to do is to use a backdoor approach to bring those matters into the records on the archives of Parliament, and we must not allow them because they are breaching the rules of Parliament. You know, the fact that we have rights to speech does not mean that those rights are unfettered rights. Where the content of your speech is infringing on other people's rights and has the potential to impugn the integrity of other people, you must not be allowed to do so. And I think that's exactly what is happening here. And I'm hoping that when we return back, the chairman of the committee will stamp his authority and move forward. Because in any event, what we do here is just a parliamentary practice and a convention. There's nowhere in our rules that says that when you can give preliminary comments. So if only preliminary comments is taking us close to 2 hours, why should we continue to allow it? I think that the speaker should be bold enough to move the process forward so that we can finish considering the nominee.
Thank you. So that is the MP for Madina, Francis Xavier Sosu, who believes that once the meeting is back in session, the chairperson should be able to stamp his feet to the ground to ensure that this process takes place as it were and as it should, so that we don't get to see another stalemate or another form of drag or dragging or litigation, as it were, as we saw happen earlier. And so that has been the situation from this room. We're currently, the appointment committee has gone on a break, a short break indeed, after that 2-hour stalemate between the majority and minority leaders to more or less allow cool heads to prevail. And then after that, we would have the meeting come back in session. So we are keenly anticipating and waiting that chairperson of the committee would call the meeting back to session. And after that, it is expected that the actual process of vetting the Chief Justice nominee would resume or would commence, because one would say that the earlier one we've seen has just been more or less like rebuttals and objections from both leaders of the House. Back to you in studio. We are back when the action is back.
Thank you very much. Christian Yali is my colleague there. We're still on Zoom with Christian Malmhesi as well. Council, perhaps I'll just ask one last question, then I let you go. Barring any unforeseen challenges, Justice Paul Baffoe-Bonnie will be vetted and will be approved. What do you foresee as the possible hurdles you have to surmount in turning around perceptions, amongst many other things, challenges really, which could come up for him?
Please, could you come again? Could you come again with your question?
I was asking that barring any unforeseen challenges, he will be vetted, he will be approved. How do you expect him to go above possible challenges and hurdles that could come up during his time as Chief Justice?
Oh, I mean, definitely the only possible hurdles would be the lingering legal challenges that the former Chief Justice would put up. aside that Justice Baffoe-Bonnie would have a very smooth tenure, and he is very qualified to occupy that particular position, and definitely, should he be approved, I mean, members at the bar can only wish him all the best. But by private rights, the former Chief Justice is still in court, and she's still seeking to assert her rights. So that would be a development that would keenly follow, and where legal education is required, would render to the general public.
Right. On that score, already we're seeing the concerns of possible conflict of interest amongst many other things. How does he begin to cure it, if it's curable in the instance that we're seeing play out?
I mean, there are authorities that speak to the fact. Conflict of interest will not come up because should he be approved, he becomes the Chief Justice simpliciter, and the Chief Justice, by decided authorities, his function is to empanel, and in doing that is what it is. There have been cases where those matters have been brought up, and the court has decided and cleared that particular position that where the Chief Justice is carrying its administrative function to an empanel, that cannot be a derivative of conflict of interest, unless it clearly shows or that he has demonstrated that. So definitely, whatever cases that will be exercised privately by the former Chief Justice, and empaneling is required, the Chief Justice, as he may become, will definitely carry that administrative function, see to the judicial conclusion of it.
Mr. Harris, I'll have to hold you again. Production says that you cannot go just as yet. I'll go on to the other Zoom where Professor David Abdullah is joining us as well. He's a governance expert and also plays a supervisory role at the Africa Parliamentary Network. He's joining us this afternoon as well for a quick chat in relation to what it is that we've seen play out and this stalemate that we're currently having. Prof, I appreciate you speaking to us as well. You're vexed in terms of the matters relating to procedure and rules and proceedings within the legislature. From what it is that we've seen play out, does the minority have the rules on their side in deciding to make the comments that they've made and to insist on their rights to be heard even before the vetting starts proper?
When you, not even going to the rules, when you say preliminary, if it's preliminary, you are supposed to say something brief.
Right.
You are not supposed to, take a very long time, close to about an hour, try to, say something brief. And I think now, when you go into the rules, I think the majority leader was just trying to, bring to the attention of the minority leader that it should be within the rules of the House. So whatever he was saying, he has a right to, but if it is within the rules, I think there shouldn't have been any problem. I think everything should have proceeded very well. And if he had other issues to raise, probably during the time of when they are vetting the nominated Supreme Court Justice, then he could have brought them. And I think nobody could have been able to stop him.
Right. Prof, I'll just kindly ask that you turn on the camera so we can see you as you make the submission. But considering this is not the first time we're seeing this play out, we've had a number of vetting sessions already in this year alone, and this has come up repeatedly. The minority seeks to make an address, the majority disagrees, they go on a break, they return. That has happened for quite some time. Is it for a lack of a conference before the sitting which continues to see this play out, or it's a case of the minority just wanting to have their way on this one?
I think for far too long, our parliament has always been a parliament that is very, very polarized. And at the end of the day, you see each of the leaders trying to make a political point. And the issue is not that you cannot make a political point, but within Parliament, there are rules and regulations. And it is simple that we must follow the rules and regulations, which is what is bringing this back and forth. And for far too long, I mean, I have said, even on this your platform, that the kind of behavior the minority leader is projecting, to me, it doesn't fit into what leaders should be. Whether he likes it or not, he's a leader in this country. He's a political leader. But leadership is about being able to, rise up to the challenge of leadership. And the challenge of leadership is to, most of the time, to do the right thing. So I think as we move on, I think Parliament and parliamentarians should understand that you are representing a group of people, and when you are speaking, you should understand that even though you represent your constituency, you're also speaking for Ghanaians, and you should temper that politicization with a little bit of pragmatism, making sure that whatever you say, people are watching and listening. And I think you should make your views clear. You should also make your ideas across, but make sure that at least you respect the rules and regulations of which you are a member of that particular parliament. So that's where I see the issue. Now, can you imagine if you are driving and you get into accidents? So as you see, one must always, make sure that we obey the traffic signs. And I think that is where the challenge is coming from.
In obeying the traffic signs, I'll just say that we just lost your visual, and if you could kindly just rectify that again for us. On the subject matter, we had the majority chief whip make a point that, look, of the many issues they were seeking to raise in this preliminary address, it was subject matters which had been decided upon in a motion they had tabled before the House. As such, they were using the back door to try and relitigate or reintroduce the subject matter. In your view, could the chair of the committee had identified that and said, look, these were matters which you raised in the motion, the speaker ruled on it, and so you cannot bring that before us again, and then proceeded to allow the vetting to take place?
No, but I don't think it's right, because the speaker has already ruled on it. Apart from the fact that the speaker has ruled on it, the minority speaker is a lawyer, but apart from that, also he's a senior member of the House. He has been a majority leader before, and he has been a minority leader now that he is. He understands the standing orders, and I think he should have, actually go by the standing orders. But I think where I don't see with what the minority were trying to put across is the whole notion of saying that, say something brief, and as you move on, if you have any issues, I mean, you can couch them in a different way to be able to get the same answers that you want, or to be able to get your same ideas across. But if I'm supposed to say something brief and I'm taking close to about an hour to say what I have to say, it doesn't make any sense. It is really interesting. And if it is to obey the rules and you try to skirt or go around the rules, definitely I don't think that a lot of Ghanaians will like that. The nominee has not yet spoken. If the banter was between him and the nominees, then I will understand. And I think that is where I see it differently. I think the minority leader should have been brief to the point, and maybe whatever it is that they have to say can be brought on during the vetting process and the questions that they have to ask.
And on that subject matter, they've gone on this very short break. It's looking like it will take quite a while. The conversations will happen in the back door. When they return, would you be expecting that the chair will allow the minority proceed to make the point, or a decision will have to be taken for the vetting to take place?
I think the chairperson must lay down the rules and make sure that if you are going to go beyond the rules that we are going to operate on, it won't work. And also, he must make it very clear that this is to vet a nominee. So at the end of the day, all questions must be germane to why you are there. We are not there because you are going to legislate a particular issue. It has already been, the speaker has already ruled against that, and I think his ruling has made it clear that we shouldn't bring it back there. I think the questions should be about whether the nominee is qualified. And I think in the plenary interviews of most of the people, even the minority, no one is talking about the fact that he's not qualified. Then if there are issues about his experience or things that are germane to the work, or whether he will be someone who would be a Chief Justice for all Ghanaians, I think those are the questions we should be talking. I remember in a particular briefing, vetting, when the current Deputy Attorney General was being vetted, I think this same minority leader was asking him that he should sing an Ever song or something like that. And to me, it was not necessary. That is not why you are there. I think when they come back, the chairperson must be strict. Whether it's from the majority or minority, he should be benefit Ghanaians and lead to benefit the judiciary. I don't think he should beat about around the bush. One thing about being a chairperson is that at this particular point, whatever it is going to be, you must make sure that you are strict about the rules and regulations that guide the hearing. Yeah.
On the management of vetting, which will go forward, because quite some time already expended, is it nearly 2 hours on just this mere process of whether or not the minority should proceed in making their statement. When they do return and the vetting starts, there'll be the concern of questions and how long the questions can be asked as well. Considering the amount of time already dispensed on this subject matter, would you be expecting tougher regulations as to management of time, amongst many other things, vis-a-vis the opportunity to ask salient and very important questions?
Yes, I think it should. I think at the end of the day, the chairperson should be strict and make sure that questions are succinct and direct. You're not supposed to give, you're not writing a dissertation or you're not going to talk very much. Be succinct, ask pertinent questions that is going to come out with what we want. Is he qualified? Is he not qualified? Does he have the experience? And knowing that he's the oldest person on the bench, all these things should come into their consideration, that you are not going to ask somebody who would not know how to answer the questions. So I think when the chairperson comes, my opinion would be that he should be very strict, either with the majority or the minority in the answering of questions, and make sure that we move the process ahead. If not, we're going to be there for the whole day and all night, and that is not going to benefit us. I think questions should be asked, and the questions should be things that should make him be able to really let Ghanaians see how he can go about managing our judiciary, making sure that the rule of law is enforced and so on and so forth. Not frivolous stuff. They should ask him things that are germane.
Just hold you as well as counsel just a while longer, because we have to make a return to the committees room 1 and 2 and get quick updates from Christian Yali. Alfred Okanse as well has joined me here, but we'll just go back to the committees room 1 and 2. Christian, provide us with updates as to what's been happening since we left you, some development from the committee rooms.
i.e. the vetting of the Chief Justice nominee Paul Baffoe-Bonnie, which has unfortunately hit a stalemate following earlier remarks or descriptions by the minority leader that the nominee is a disputed nominee. He also had described his appointment as political, and then went ahead to attempt to address the work of the Puaman Committee, which considered a number of petitions that were submitted before it, which subsequently, one of which led to their recommendation that the president removes the former Chief Justice Gertrude Tokonu from office. And so after that, the minority leader, in that preliminary comment that he sought to give, mentioned, for instance, that the work of the Appointment Committee was a travesty of justice, which the majority leader objected to. In fact, almost every line of his submission was objected to, which resulted in almost 2 hours of a stalemate. In fact, no single question was posed to the Chief Justice nominee. And so that eventually and subsequently led to the committee chair calling that there be a break. Indeed, he does not tell us how long the break should be, but what we know is that currently leadership of the committee are not in the room. Probably they are considering one or two things, and then after that they will come back to call the meeting to session. Then the vetting itself properly would resume. But what we know is that the majority leader on any other instance has made the case that he is not going to allow the minority leader offend any of the rules that govern how business is conducted in the chamber and in Parliament by the various committees. So what it means is that he wants the standing orders strictly adhered to, and also what the Constitution says. Rightly so, he makes the case that, see, if you are raising issues against the persons of certain individuals who are not around and do not have a right to even respond to such issues that you raise, then indeed this does not become the forum for you to raise such issues. So he has sought to object every step of the way utterances or statement deemed to be a breach of rules by the minority leader. In fact, it got to a point that it was getting heated up, for which reason the chairperson of the committee, Bernard Ahia, for who doubles as the first deputy speaker, directed that there is a break. We don't know exactly how long that break is going to be, but we know that so there are a number of members of the leadership of the committee who are around, and very soon we should see the nominee brought back into the committee room. And yet, what other story I have to tell you is about the patience of justices from the Supreme Court, as well as other judges who are still here waiting patiently for the meeting to be called back to session. We have a number of respected traditional leaders as well who are still around waiting for the vetting process to resume. What it tells you also is that that story, that one that people talk about, a love story that is brewed in the public space about the wife of the CJ nominee who happens to be the Director General of the Ghana Prison Service. So there are officers from the prison service who are also here heavily to support in that regard. So very soon in earnest, and Alfred and team would have the meeting called back to session. But we're talking about someone who has gained some great experience, currently serving as the senior most judge on the Supreme Court bench. And indeed, what it also tells you about is that he has risen through the ranks over the years to get to where he is currently. He's been at the High Court, has been at the Court of Appeal, and even before coming to the judiciary has done a lot of work in public service, served at the prison service, and has been a great officer of taxation as well. So when you talk about the profile of Justice Paul Baffoe-Bonnie, it is one that extends into other areas or facets of life, even before coming to the judiciary. But for a career spanning over 3 decades, indeed, when you ask some members on the committee, they tell you about what they expect of him by way of his responses to some key issues that deal with legal education in Ghana. You know that the Attorney General is working around bringing a bill to Parliament which would see to more or less decentralize legal education, such that, for instance, when you go to the University of Ghana School of Law, you are able to write your legal education examination there and be passed as well, without necessarily going to the Ghana School of Law or what you call Makola to get all of those ones. But right now you see that the majority leader has just joined some of the justices here to have some chat with them. Also, a very beautiful way to engage them, even as we wait. But I want to see if I can engage the Member of Parliament for Salaga South for her views, really, or expectations, really, of the vetting process and what she expects of the nominee as we prepare to have the meeting called back to session. She has been here all through and has witnessed the process as it has been over the period. And so, thank you for joining me. You are live on TV3 Ghana. Really, what has been your observation so far, and what do you make of the process, your expectations as well, going into the remainder of the process?
Well, thank you very much. I came here and I think there's nothing that happened here that I didn't expect to happen. We had seen attempts to get today's scenario played out at plenary, where Mr. Speaker had to stamp his authority and refer to the laws and the orders of the House to contain the situation. And so when it started playing out, I wasn't surprised. But I think it gets to a point where we all have to hold on to what we can hold on and leave what we cannot. And so I was expecting that our members of the Appointments Committee will literally get along, vet the Honorable Nominee, and then we can deal with the residual issues. It's not, I don't think it's a good experience to make Parliament look like a place where, I mean, we are not valuing time. After 2 hours, we have nothing to show for it. Time is a resource that you can never get back. There are many of us here who would have utilized the last 2 to 3 hours. So that is my greatest worry, that things have to be done and they have to be done. There are times for other things. And so the attempt to literally turn the Appointments Committee into a minority forum, for me, I think it's not on. It's an Appointments Committee. We must stick to the rules. And if you have the leader, the majority leader, he indicated that the privilege of allowing a member to offer some preliminary statement is not a right. It's just something. So if we tend to abuse it, what it means is that we might lose that privilege in future. So I'm hoping that they'll be back on time, and then we'll get it going. I believe in the president's nomination. I know due diligence was done to settle on Justice Baffoe-Bonnie, and we're looking forward to a renewed Supreme Court once he's confirmed that his conduct, his work will bring back the confidence that we all had in the Supreme Court. That is what I'm looking forward to.
Thank you so much. So that has been Honorable Zuwaira Ibrahim, a Member of Parliament for Salaga South, also her views on what has transpired and what it is that has unfolded over the past 2 hours or more. Let me see, maybe I can engage this Member of Parliament also to get his view really on all that has transpired. Honorable, can I get your thoughts briefly? Briefly, you have observed. Okay, that is fine. That is fine. So I'll get him in a jiffy to share his views really with me. But that is what it is that has transpired so far. A process that was expected by many to be as smooth, unfortunately hit that stalemate over all that we've told you about the background story, which you're very much aware of, as it were. And now we are on a break. It is the reason you don't see the vetting happening. The chairperson, Bernard Ahiafo, called that there should be a break to allow cool heads to prevail. And then after that, we will be back with the rest of the process to follow or to continue. And so that is it. Very soon, indeed, leadership, and especially from the majority side, is still around. Indeed, I see the Honorable Mahama Yariga still engaging the guests who are still seated patiently trying to get their thoughts. And so I will seek to get briefly some words from another member of parliament, just on his expectations and how things have been over the period. So Honorable Zidane, member of parliament for Laura, joins me right now. Just some quick chat with him, and then we are good. And so, just briefly, you have observed the proceedings so far. What do you have to say?
Well, thank you very much for the opportunity. Honestly, I'm very much disappointed about what took place, because basically we have come here to vet a nominee, and our business should be how we are going to carry on with that particular responsibility. And you have a minority leader who introduces extraneous matters which have nothing to do with the vetting. And so I'm disappointed about that, because all that he's saying, there's an opportunity for him to say that, and he can do so if he organizes a press conference, and then he can have all the time to do that. If he wants to spend 3 hours, that is his cup of tea. But no one will come to do this important job of vetting a nominee. I don't think that is right.
So I want to say he has his right to air his reservations or his views.
He has the right to air his views, his reservations, by asking questions. That is what he should be doing, and not say that he's coming to make preliminary comments and spend 2 hours making the preliminary comments. Why? That's not a right. Every right must be exercised with responsibility. You don't have to abuse the right that you are exercising. It's a complete abuse of the process.
Thank you so much. So that has been the Member of Parliament for Laura, Zidane Anwanta Zumo. He's the MP for Laura. He's also shared his views on all that it is that has transpired. See, Alfred, that is all that has played out. And I know that you know all the details thereof. And so we are waiting patiently when this is called to session, when this vetting is called to session. We'll be back to bring you some more updates on all that it unfolds. And as it were, TV3, we are going to carry everything live throughout. And already, when you get to our socials, we have all of those clips and quote cards and the rest of all the key items that took place earlier. And so you can still keep yourself abreast of the issues. Alfred, you and the team can take over. We'll be back when we are back live with the vetting.
Right on. And Christian Yale, they're live from the Appointments Committee sittings, and we'll still continue the coverage of the expected vetting of the Chief Justice nominee. And it's just on a break because of the hiccups that we saw that characterized the early part of this process. But here's what we do know, that all things being equal, this vetting will proceed in the coming minutes ahead of us. So we're there for you here on TV3 and also on 3FM 92.7. And let's go on to the telephone lines right now. Let me just acknowledge the presence of Kweku Ansah-Sarry, a former director of the Ghana School of Law. Also, we still have Christian Mamhesi, is a private legal practitioner. Professor David Abdullah is a governance expert. And then also an executive director of the Africa Center for Parliamentary Governance, and he's also been contributing his thoughts and views on the issues playing out right now. Quite a number of people are at this particular Appointments Committee to witness the vetting of the Chief Justice nominee. And Marietta Brua-Piopong, a former Attorney General of the Republic of Ghana, we saw her there in a chat with that's the Majority Leader, Mama Yariga, right behind Christian Yale. Now, Kweku Ansah-Sarry is on the telephone. Ansah-Sarry, thank you so much for joining us on TV3. Hello, Mr. Ansah-Sarry, can you hear us? Hello, Mr. Ansah-Sarry, we'll try to reconnect with Kweku Ansah-Sarry shortly to get his thoughts on what has transpired so far. He is actually at this vetting, the venue of the Appointments Committee, where this vetting of the Chief Justice nominee is taking place. So he has a fair view of the interactions even outside of what we are seeing on television. And so we'll connect with him shortly. Christian Mamhesi is connecting still with us here on TV3. Counsel, now, there's been a number of things that Mauna has established with you. One of the issues you see quite clearly is that, as expected, the Chief Justice nominee has a solid support and the backing of that's the justices of the Supreme Court. Not because of his current portfolio, but also having served as a senior most over the period. In fact, being appointed onto the bench sometime in 2008, he comes in with some experience, is it not, that would then galvanize that kind of support and the backing of all the other justices of the Supreme Court. How do you expect that camaraderie to play out if and after he is eventually approved by Parliament? If you could unmute for me.
He comes in with a wealth of experience. I mean, from when he was appointed to the bench under the tenure of
that's John Baffoe, yes.
And he has risen through the ranks. He has risen through the ranks to the highest or the apex court. Indeed, being the senior most would definitely come by experience and also career progression. And definitely through that, he would have definitely courted the confidence of his peers. That is the reason why you are seeing his peers around him to shoulder him through this particular vetting. And definitely, once he has existed in that particular position for all this while, there will definitely be that relationship built. And also, I mean, in developing the jurisprudence of the country as far as judicial precedent is concerned. And so he comes in with a wealth of experience, and it is our belief and hope that given how things have turned out, he will definitely shoulder and direct the judiciary to the pinnacle of justice that the masses expect. Because just as we know now, or as the law prescribed, law emanates from the people, and definitely that is what Parliament is seeking to do. That Parliament is a representation of the people, and it is deemed as the people through Parliament are the ones vetting the honorable nominee or the justice nominee, so that when he assumes the position, we would see a more robust judiciary, a judiciary that will deal more with its administrative bottlenecks, a judiciary that will have infrastructure partnerships with deepening relationship with local governance institutions, because the district assemblies and the municipal assemblies, they are supposed to be working with the judiciary so to develop district courts and other court infrastructure across the country. We are seeing that poor development, or we've not seen much in that area. And it is our prayer that we are going to have such relationships developed to ensure that justice delivery is enhanced. We are also going to see that most of the courts are going to have are going to have the presence of judges more, because we have experienced situations where in some courts for whether promotion, which hitherto should have been anticipated by the judiciary, have not been catered for, and that has caused the absence of judges in those courts. And when that happens, it's either there will not be substantive judge to hear the matter, and creates expensive litigations. I mean, I'm a victim of that. That's why I'm saying that in a number of cases that I'm involved in, especially this new legal year, we've had the incidence of that. And where there's a relieving judge, that person probably comes once a week. And when that person comes, we would only want to deal with few cases that he or she could handle. And so all of these administrative bottlenecks exist across the country, and it is our prayer that we are going to have His Lordship deal with most of these things, so that justice delivery would be more accessible and less expensive.
Well, and you see, all of these challenges that you outline, quite telling in terms of its impact on justice delivery, because you are an officer of the court, You know the realities in terms of the bottlenecks that impact on the justice delivery system in this country. That's why you talk about all of these administrative issues and so on. I do know that there's been some, digitization interventions and so on. There's software that were purchased to address some of these bottlenecks. The last time I checked, this software that was purchased, thousands of dollars, it's not being utilized to its optimum, expectation. So what's going on? You are an officer of the court. What's happening?
Again, thank you. With these softwares for filing and all of this software basically exists just within Accra. And even in Accra, it's mostly concentrated at Central Accra. At the court complex, you have it functioning more. If you move to certain parts of Accra, you don't have this software so-called existing. Indeed, even other parts of Accra, just travel down, going to Waja, going further down. There are some of the circuit courts without computers, and I wonder how. We can only pray. Let me withdraw that. I wonder how. We can only pray that there will be a hands-on on the administrative aspect, because the administrative aspect of justice complements the real justice that is dispensed in the courts, and that is what should be enhanced. Because it has made practice quite difficult, more especially if you would have to travel all the way to say Kufuridua or Ho for court. If a judge is not sitting, you would not know unless you get there. And chances are that if the court clerk is magnanimous and there has been a creation of a WhatsApp group, that notice will be put in there. But even with that, the notice could come in, and then the very 11th hour, you'll be told that the judge is sitting, and you'll be left out, and you'll be forced to take a date, and that will be more cost to the client. And when you're explaining that to the clients, they just can't understand it. They think you want more money from them because transportation, they have to pay under the Ghana Bar Association scale of fees and the incidental cost. They have to pay transportation, which is devoid of the legal fees. So the scale of fees enjoins us to explain that to them before commencement of work, and also to sign legal service agreement. So there are always two costs that they pay: incidental cost and then the legal fees. So when these administrative bottlenecks are dealt with, it is going to help a lot. And if we have these serious problems in Greater Accra, you can imagine the hinterlands. So it is for me, the administrative aspect is very, very important, and I pray that definitely as the incoming Lord Chief Justice, we pray that his attention would go to that aspect, so to make the work not just at the bar, but justice delivery across the country very, 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 very accessible, and it would also make it less expensive when we have expedited cases happening. Again, talking about expedited cases, because of the poor implementation of the software, or the less expansive reach of the implementation of the software in other areas.
In fact, it is that point that I want to hold you on to.
It has also affected.
I want to hold you on to that point about the cost of the implementation, because then again, you mentioned how that is also impacting on the cost to the client. So hold on a bit for me. Alhaji Yunus Afuseni is a former member of parliament for the Tamale Central constituency, former Minister of Lands and Natural Resources. He's also held a number of portfolios, serving as minister to contribute to the development of this country in many ways. He's a private legal practitioner in good standing. Alhaji, good afternoon. Thank you for joining us. Hello.
Hello.
I can hear you.
Yes, I can hear you. Thank you for having me.
Great. Now, if you haven't been watching what's been happening so far, the appointments committee, just summarize it for you. The minority leader raised some objections and concerns, and which has led to a temporary break in the vetting of the Chief Justice nominee. Although this was expected, that is either they walk out or they come in and make their case about some of the concerns that they had raised prior to this moment concerning the removal of the former Chief Justice, and then also how Justice Gabriel Scott-Palman, as well together with the other members of the committee, conducted their work. Now, with this hiccup that has been experienced, which has led to this break, how does all of this strike you, especially because it is also impacting on the vetting of the Chief Justice nominee as we speak?
Well, thank you. I think that what is happening is very, very unfortunate, and it's marked of some level of indiscipline on the part of members of parliament.
Why do you say so?
Because the members of parliament exercising their rights under parliamentary procedure filed a motion with the speaker. That motion came before the speaker, and the speaker ruled on that motion. So that matter has been settled, and you cannot go back to the vetting and seek to raise these matters which you tried to raise by motion and which was rejected. And it's marks of some level of indiscipline on the part of the minority in trying to do that through the back door.
Why do you describe their process of letting their own reservations and grievances be known as an act of indiscipline?
Because they have invoked the procedure under the parliamentary rules to have their matter heard on the floor of the House. There is if you want, a winnowing process for the receipt of motions or admission of motions. The motion came before the speaker, and the speaker, in his view, thought that the motion, or ruled that the motion was inadmissible. That should end the matter. That should end the matter in the sense that because they invoked the lawful procedures of Parliament and the authority of Parliament that has the power to decide whether or not the motion was proper before the House, ruled otherwise. To come back and raise the same matters or try to raise the same matters at a committee hearing can only be described as indiscipline.
I see, but then how else or which other process could they have employed to still let their grievances be known or their reservations be known despite
so when the speaker, there's a rule of Parliament which says that if a person disagrees, if a member disagrees with the ruling of the speaker, he files a motion challenging that ruling. There's a rule of Parliament. So it is not like, there's no remedy to that ruling. There's a remedy, and the remedy is that you file a motion challenging the ruling of the speaker.
But then again, that would have been after the fact. That would have been after this vetting. And they thought that this was a prime opportunity to still state their case, even before the vetting.
The fact that you do not have the time to do that does not justify using illegitimate means to bring your concerns to the floor of the House through the committee.
See, now this has led to this vetting process being truncated, at least temporarily. How do you expect the chair of the appointments committee to handle this after this break?
Well, when the word was used, the leader of the House ought to have, of the committee ought to have called upon the majority leader to withdraw that word. And if he refused, could expel him from the meeting, could get him to leave the meeting, because that would be insubordination to the authority of the chair of the committee. And so this ought to have been the procedure. You should have gotten him to withdraw. If he refused to withdraw, to get him to leave.
It's two things. I mean, well, they didn't ask him to withdraw. They've gone through this process of going for this quick recess. It's a stalemate, yes. But then again, two things may happen after this quick recess. It's either the minority would come back and still take advantage of this process to state their case, or they would walk out of this vetting process. How do you expect both to play out, especially when it comes to the majority or the chair of the committee handling the process, if these two likely events take place?
The best way out is to use the parliamentary processes. The parliamentary processes safeguard the minority from the arbitrariness of the majority, and safeguard the majority from the tyranny of the minority. All based on the parliamentary process. So if you don't follow, or if the committee says, refuses or neglects to follow the parliamentary processes, that stalemate will persist. The majority or the minority would have its say consistent with the rules of parliament. If what they say is not consistent with the rules of parliament, there are rules in the standing order that deal with any matter that is unparliamentary. And they must learn to invoke such provisions and such rules. If the majority decides that the minority should not speak, there are rules of parliament encapsulated or found in the standing orders that protects the rights of the minority to speak at such committee meetings. So the best way out of a stalemate is to go back to the rules of parliament, the standing orders.
I see. Now, hold on a bit for me, Alhaji Yunus Afuseni. Kindly indulge me as Professor Abdullahi. You hear Alhaji Yunus Afuseni talk about the chair of the committee safeguarding the sanctity of the process from the tyranny of the minority. These were the words that he used. I mean, has the chair of this committee, Donald Bernard Ahiafo, been able to assert the authority that this position gives to him in implementing the exact rules of the House and the standing orders as expected, that would be able to preserve and protect the sanctity of the process from whatever disruptions that would come?
Well, first of all, I think he has not asserted his position enough, because by asserting his position enough is to be fair, but also it should be within, the standing rules of Parliament. And I think he has tried. I think he's been on similar committees with the minority leader, and he has tried at least to give him an opportunity to come up with his views and so on and so forth, except that, it should be within the law. It should be within the standing orders. If definitely he is to assert his position, I think he should make it very clear that, if you repeat X, Y, Z, I'm going to make sure that I let the rules pertain. So I think Alhaji was basically, as a former member of parliament, is actually telling you that each, either the minority or the majority, each and every one of them have rights as well as responsibilities in performing their legal duties as parliamentarians. But if one particular, if the minority or the majority is trying to capture, the hearing in a certain way, the chairperson must make sure that they assert their, their chairmanship without any doubts, and it should be right on. And if any of them then see it not in their liking, then of course they have the option either that the chairman lets you leave or you can leave by yourself. But I think at the end of the day, what is very important is that I think, Nene, we have seen this before, whereby the minority speaker in committees like that had actually always gone off point. I think there was a case he asked one of the, the nominees to sing, and he has asked even the current, Deputy Attorney General to dance, and all those have nothing to do with vetting. It is basically to make sure that the person who is vetted is qualified, has the requisite credentials, has the experience, and is going to dispense, justice and fairness in their position. And I would employ the appointee that, as I've always said, that leadership is not a popularity contest. I think he knows that when he goes in there, he's not in Hollywood. He's going to make sure that he delivers. And by delivering, the previous guests on the show have already talked about the challenges that we are facing in our judiciary and the delivery of, justice in our system. So definitely, he must go about the challenge of managing, making sure that our courts work efficiently and thus deliver justice. I also think that at the end of the day, having his experience and having been so, he's been on the Supreme Court as someone who's now the most senior of all, should apply that in such a way that he brings all of the people along, because some of them will not support him. And those who will not support him doesn't mean that he shouldn't bring them along, because he's going to be a Supreme Court justice if he's approved for not only his colleagues, but also for the whole of Ghana. And I think at the end of the day, that is what we want, so that our democracy can move forward. And at the end of the day, we must always remember that we're a developing country. Even the developed countries, they have challenges. And those challenges doesn't mean that they cannot move things forward. If you look at it right now, even at in the US, the Congress, they are at a stalemate, whereby the Republicans and the Democrats, have shut down government. But at the end of the day, they have to talk together and make sure that it's taken care of. So I believe that Alaji was saying that the chairperson, when they come back from the recess, must be very, 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 tough on the rules and make sure that the processes move forward, so that at the end of the day, we are able to come up with the approval or whatever of the nominee.
See, Prof, and stay with me a bit. And Alaj, are you there? Can you hear me?
Can hear you.
Perfect. Do you align with this thought process and the position that Professor David Abdullah espouses, that Bernard Ahiafo has not asserted his authority that much as expected as chair of the committee, even though the powers and the standing orders does give him the power to ensure the sanctity of the process without necessarily having it get chaotic?
Well, I have worked with Bernard Ahiafo when I was in Parliament. I know him. He knows the parliamentary rules. He's a forthright person, but he's also a team player. He wants to move everybody along. He wants consensus to animate the process, and so he always bends backwards to accommodate his colleagues on the committee. And we saw that during the vetting of the appointment of the nominated ministers of state. So I think that's his style. Many people were not impressed with his attempts to bend backwards to accommodate his colleagues, and particularly the minority leader. But these as is may, I know Bernard Ahiafo, and I know he's a forthright person, and I know when he comes to the conclusion that his efforts are not being appreciated and reciprocated, he will take the necessary decisions.
I see, and that leads to the next question about how, going forward, you would expect the sanctity of this process to be preserved. What should he do? As you say, you know him.
The consensus is that the standing orders must animate, regulate, and inform the way a committee of parliament performs its functions. If what a member is doing cannot be found in the standing orders of parliament, that committee, that person will be out of order. That member will be out of order. And it is for the chairperson of the committee to so state. And that chairperson, the chairperson of the committee, and particularly the appointments committee, has enough powers under the standing orders to deal with any recalcitrant member who is determined not to follow the standing orders of parliament. And so I believe that Bernard Hiafo, who is the first deputy speaker of parliament, is quite aware of the enormous powers he has as a chairperson of the appointments committee, and will demonstrate that authority if the need arises.
Alaj, and before I let you go, let's come to the man on the hot seat now. I'm talking about the Chief Justice nominee, Justice Paul Baffoe-Bonnie. It's a man that you may have appeared before him. I mean, he has served at the Supreme Court bench for almost 18 years now. You know, for the politics of things, I mean, he comes in with that kind of united force, is it not? Having been appointed by the former President John Ajay Kufuor to the Supreme Court, and he served all throughout to this moment when he has been nominated as acting and now the substantive Chief Justice nominee. If approved, he's going to have just about a year to serve as Chief Justice. What are your expectations of him?
So a year is enough time for the Chief Justice to bring some sanctity, respectability, and dignity to the bench. By just putting in rules and procedures that clearly would animate what the court does. And so yes, he has not much time on the Supreme Court, but then he can do a lot to ensure that the instability that has characterized the Supreme Court of late becomes a thing of the past.
Yes, and I appreciate it. He's a former member of parliament for the Tamale Central constituency and a former minister for lands and natural resources. As you just saw on the television, we're going back to the appointments committee right now because the Chief Justice nominee, Justice Paul Baffoe-Bonnie, has resumed his seat, and the members of the appointments committee are also resuming their seat. The vetting process is going to resume shortly. And as I did indicate to you, that we have quite a number of the justices of the Supreme Court present. You saw there Justice Gabriel Scott Puaman, who was the chair of this 5-member committee that was established as per the dictates of Article 1469 of the 1992 Constitution of the Republic of Ghana, that had the petitions, and then also gave the former Chief Justice that opportunity to also have her say and respond to those petitions, and eventually, based on the findings, made a recommendation, and then also said Justice Dennis Ajay, all of them in there as well, Justice Napari Battels as well there, Supreme Court Justice. Let's cross over to the Appointments Committee right now. The chair of the committee is just putting mergers in place and dictating what has to be put in. Let's hear from Alexander Penyumaking, who is talking now.
Whilst there are credit cases by the leadership, Justice Arthur we as Parliament
So we'll rectify the connection to the Appointments Committee shortly, but that is Alexander Penyumaking, the minority leader, the Futu Member of Parliament, who is making a statement. Let's cross over right now to hear from them. They're making their position clear on the concerns that they had already indicated surrounding the removal of the former Chief Justice, Justice Gertrude Araba Esaba, Saki Tokono, and the reason why they had taken that position and how that is going to inform their position as well on the committee, the appointments committee there in Parliament. We'll cross over shortly to hear from Alexander Apenyomakin, who is making a statement right now at the appointments committee, whether or not they will continue to take part in this process.
My Lord, Justice Baffoe-Bonnie could continue serving in acting capacity until the courts have provided clarity on whether her ladyship, Justice Araba Esaba Tokonu, was lawfully removed. In our view, all that is happening does not amount to some objectivity at play. We rather see a fair accomplishment. Chairman, it is also our view that for the sake of our country's democracy and rule of law, the grant of 3 weeks extension for the learned Attorney General for leave for extension of time was rather unacceptable after the long delay in filing an opposition.
Chairman, please. Chairman, this has to be withdrawn. This has to be withdrawn.
We won't listen to you. Chairman,
please, we heard what he said. You clearly, you can't sit here and malign a decision of a court. It's not acceptable. It's not acceptable. Please, don't let us keep doing this, and then send the impression out there we are bad people, we are a minority trying to prevent you from. The rules are clear. You've been told the rules severally. Please, please.
Chairman, I'm sorry. I think that Chairman, we have to help you. With respect, we have to help you. My leader speaks at will. He speaks at will. We all know the practice in this house. Leader, you have to catch the eye of the speaker. You have to respect the chair. This attitude of suddenly punching the microphone and speaking, you are our leader, but you are a member of parliament. You are subject to the same rules as apply to all of us. So, Mr. Chair, I think you should have a word with our leader.
Thank you very much.
Your consent.
Honorable Minority Leader, be guided and candidly land safely. Yes, Honorable Ayarga.
So I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting the rules. Because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So you have to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly. And proceed.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court, and it's our right to have a disagreement with the court, most respectfully. Especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree with all due respect with the decision of the court. And when you disagree with the decision of the court, you know what to do.
That's not a problem. But we are making a comment, Chairman. Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court on ruling and say on this we disagree. What is happening here? Because somebody has supermajority? What is happening in this country?
Minority leader,
What have we done wrong?
I will not have a problem.
I have not attacked any judge. We've not attacked the
by
court.
way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what it is. That's
just
exactly what
stick
it's
to the rules.
I don't have a problem.
Make your preliminary comment as such.
Very well. Chairman, thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba-Tokono. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy. A strategy to ensure that these cases languish undefended, creating space for this right competition to proceed.
Yes, Honorable Ayariga, let me hear you.
Why?
Now and then, the minority leader will say that we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives or impugns the integrity of a member or any other person. The Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution, and he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear. That any reference to the conduct of persons mentioned in Rule 7 in any amendment, question or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed
he has impugned improper motives, we should order him to have it expunged from the records. And I'm saying that he has impugned, imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair,
Honorable Minority Leader, please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader, you have the floor.
He's a member. Mr. Chairman, some of my, yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure.
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised. Yes, Honorable.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, let me, please, I have the floor. The majority leader is not about, if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited is on motions. What motion are we dealing with here? Now, every committee, ever since I became a member of this house, every committee meeting, people, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise the question about what I heard other people say that, well, there had been issues, nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now we have been here all day. The nominee had not even spoken a word. This objection, that objection, and
Honorable Kwame, you raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
Chairman, thank you. Oh, very well. Chairman, there nowhere in my submission did I impugn improper motives, or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that. No, Chair, he was just talking. No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair.
It's not fair. Chairman, what the rank is doing is not right. You were given 5 minutes. We spent 15 minutes. Have the floor. Honorable Dafamako, you don't have the floor. Honorable Roxanne Nelson Dafamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to you. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG applied to the court for leave to file out of time. It is a statement of fact that we as the minority are raising as part of our concerns regarding the constitutional overreach. We are not saying anything less apart from what is in the public domain. So, Mr. Chairman, the majority. I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader.
Chairman.
With all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman, with respect. Chairman, with respect. Chairman, with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman,
becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where you come, force you, speak, put on the mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very loud and clear. If you disagree with it, you know what to do. Will you proceed?
Don't worry. we are all aware of what this whole thing is leading to, so no problem. Chairman, we the minority hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokolo. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither parliament ally in political projects. It is a guardian of our constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any questions. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
You have not said that. You have not said that. Listen to him.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give right to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Yes. No, she believes in us.
The report is not ready to be voted for. We are not at the stage of approval. So your conclusion is very preemptive.
Yes, Chairman, with respect. Chairman, with
this is not what I want you to respond to.
No, Chairman, but
I don't want your
Chairman,
response
to the extent that you've raised it, I just need to.
Honorable Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected. We don't need to
agreed on your position.
We rejected, and we
agreed on your position. Yes. When it is time for voting, then you can vote again. Yes. So we thank you very much, and we wish you a very good luck. Honorable members. Yes. Honorable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we'll proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. You come and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Before I answer the question, may I be expected to, may I be allowed to read a brief, make a brief opening remark?
Allowed, you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of. I'm a justice of the Supreme Court. 11th of. I've been a justice of the Supreme Court 2008 since
17 years plus. I've been a Supreme Court judge. Before the 11th of June, for 2 years I was a justice of the Court of Appeal. Before then, I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956.
I went to Korongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. As a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekendi, 1 year in Sekendi, and 4 years in Kejetia chambers in Kumasi, where I practiced with my friend, the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988 and I underwent 6 months military training, and I was posted to Sekendi. That's where I met my wife. At the time I met my wife, he was also a Bobno rank person. She didn't have any rank, actually, a sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Duyayankanta as a circuit court judge, brought to Kumasi. For 7 years I was circuit court judge and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years until 22nd of April, when I was nominated to act as the Chief Justice during the period of the turbulence. And I'm here before you as a nominee for the position of Chief Justice. Now, if I may read my opening remarks, now that I've asked the first question.
Thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, you should briefly describe the personal values and experiences that you believe most qualify you to serve as Ghana's Chief Justice.
Thank you.
You combine it with your remark.
Okay. Honorable Chairman, it is a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our highest institution and leave it stronger than I found it. Now I am ready for your questions. Throughout my career, from prison service through the Internal Revenue Service and the Judicial Service, where I've been for the past 33 years, I have integrity. I've believed that everything that I've done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody, and that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with: that this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamokpo to ask questions. Honorable member, you are entitled to 3 questions. You may ask up to 3 questions.
Thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually will be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that's on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years. Meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rollins. Then I was promoted in 2000 and I was sworn in together with Secretary Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Baffoe. Then to the Supreme Court by President Baffoe. So if, that was 2008. So if 17 years later, another president deems it fit to elevate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rollins, Mills, Baffoe, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my Lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Would you consider that? That is between the 7th of December and the 6th of January. Will you consider introduce?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of the, as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost, it was 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that no, there was a need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with the declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the EC, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that is granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then a trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be. And before the inauguration. Thank you.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the lone ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated.
Honorable member, I think you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dafamako, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who had who joined the bench but were not 3 years also had to work as grade 2 magistrates. Her Ladyship Justice Avril Lovelace Johnson was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidia. I used to appear before her. So that was, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrates. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, as lawyers who were magistrates. But then, around the 2000s, in the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates, but they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. But they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with the career magistrates, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as your honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come out to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them, so that those who come can stay. And then again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu.
Thank you.
You are entitled to 3 questions, strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The illegal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's becoming very, very high, higher as a result of the delays that are occasioned in the courts, so that even small minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of, I was telling somebody that maybe the President even stole his the 24-hour idea, economy idea from the Judicial Service, because we have planned for some time now to introduce courts around the clock so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that. And then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to resolve the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahamaya Riga, the Leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have. No, we have.
We want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left with time, maybe we will get to a 24-hour. I'm certain the President sold his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
Very well. That is your question number 2.
My Lord, let's stay within justice delivery. A very important aspect of how we live. Cases on appeal. Previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This for some time now has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not, where we don't have them now. But it is not true that all the other regions have been suspended. No. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation, so they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, residents there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there's accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidua, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, going from here to Koforidua is so easy, even though it is risky and inconvenient, it is so short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George, And now we have the interconnectivity is so good that even now we don't go to Secondary again. We do virtual hearing of appeals for Secondary. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidua. So even if the lawyers in the case are in Accra, they still have to go to Secondary to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Koforidua and Ho. We are trying to get to a situation where lawyers will not go from Koforidua Ho to Koforidua, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in one of the parties could be in Koforidua, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my lord is getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people suspicious about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the thing that we have fed it with. But, and I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring the 6th person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper. And so I'll be very, very happy if somebody came and said, Daddy, I saw your picture somewhere. I mean, I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and two more cases are added. Then we have situations which I will refer to as institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, that was LN 140A of 1948 or 1950, 1960, 1954, LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for its security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules. And that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not the Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clocked, what we can do is that we should be able to track. Now we have a monitoring team which I'm going to reinforce, that should be able, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we grant adjournments on the ground of somebody's wife, because a lawyer says, my wife is being taken to the hospital. The judge asks us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. You have to come to court. And that is their system. But here, sometimes you have somebody coming to say, my father has died. 3 years later, he's asking for adjournment, and his father has died. 4 years later, the same father has died. How many fathers you have, you cannot really tell. So we see there's a human element to this. But we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean unlike let's say the state court, the circuit court, and the high court, we sit in colleges, so we sit in panels of more than one. So, and then we take decisions together. There is no, every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Owa. I went to the best secondary school in Ghana, Korongutma Secondary School. Somebody went to a one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it is a girls' school. Achumamai Secondary School has now become a Fiakobi girls' secondary school. So he doesn't even know whether he's an old student or... So...
my lord, he's still an old student. And the school is still in existence.
And then there is this man who went to school at Koforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovely Johnson, started from grade 2. Sergeant Jamefe started from the regional tribunal. So both below the circuit court where I started. And then there were some of us who joined at the Court of Appeal, like Sir Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulendis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensa Bosu. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. It shows that perhaps we come from different backgrounds. We will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this, and you should be able to discuss things formally and informally before things escalate. You should be able to do things. Even empaneling can create problems among you when somebody feels that this man is not being empaneled. I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice, I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Dodi Kulendi, Justice Puaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frupon was a junior to my very, 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 very good friend called Oturesel, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Hajaladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engage you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851. As of today, there are 3,562, a variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, there are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses, who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the Justice for All back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he is on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. The main condition a judge looks at is, this man I'm releasing on bail, is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum, he's trying to run away. already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant you bail, it doesn't matter the offense that the person has committed. The judge may not grant bail. But even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And Honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, these old ladies, how when they said, in my time, the Catholic priest was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree in our place, we call it in Kwankwaniase, playing draft. Every day my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say the man stole only a bunch of plantains. Do you know what it means what the bunch of plantain means to my mother? It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Nsawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, around the courts, that they'll see me, because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced, but that one is in your bosom. It's a law. That one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted parole may not even be able to go beyond a certain distance because he has a tag that gives a high alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you send to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal courts. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances?
Yes. Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible having 5 judges stationed at Tamale to take care of the north. It is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have find ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi and they will be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Ade. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected and to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.
Check if you have my sound. I'm talking. I'm using Ishmael, the one on the leadership of the committee. Yes. Okay. All right, and so we are taking a 20 minutes break. That is the directive.
TV3.
Yeah, sound check. All right, and so just about now, the committee has taken another break. This makes it the second. since morning, around 11 a.m. thereabout, when the sitting started. And this 20 minutes break, as the chairperson of the committee would say, it is to allow for some health rejuvenation. Members and guests can get to rejuvenate a little, and then some few minutes after the hours of 5 p.m., the committee would resume its sitting. Indeed, a number of conversations have transpired so far at the vetting, a number of questions that have been posed about the setup of tribunals as well. There have been issues around choked prisons, and as well issues about empaneling of judges at the Supreme Court have all come up. Indeed, that makes it an interesting one, because when you recall, in that earlier submission by the minority leader, one thing he spoke about was the issue of empaneling of judges. Indeed, and when you look at the case, some of the cases that the former Chief Justice Gertrude Araba Isabato-Kono has filed, which would require that there is that empaneling done to ensure that the substantive cases have been heard or decided. So it was interesting, but he says that we've come a very long way as a country, and as such, as part of the judicial system, we can consider as a country by roping in artificial intelligence in empaneling judges. What that means is that, and just as he argues it and makes the case, all that you need to feed the artificial intelligence with would be all the necessary details and inputs that would allow AI to more or less empanel judges for respective cases that they are so-called demanded or required to sit on. And so that is one that has come up. Indeed, as well, he has, and taking you back to the issue about the choked or congested prisons, he is of the view, indeed, that a number of times people have been sent to prison. He is of the view that sometimes that is done indiscriminately. He has even appealed to his colleague judges to be more or less sometimes moderate when it comes to the kind of sentence they give to some of those people, especially those ones that are considered to be some minor cases that wouldn't require long years or period of stay in prisons. He is of the view that there are some people in prison currently who have been granted bail, but they are still there also because in some cases they've not been able to meet the bail conditions. He reckons that some of those bail conditions are very high indeed, but he makes a good case about why even those that are on the very average level are not able to be met, which results in some of the inmates still being inside the prisons. Indeed, he has actually spoken about the virtual or e-justice system, virtual court systems, especially from the COVID-19 era up until this time when virtual hearings were introduced. But there again, the issue which he raises partly is about network connectivity. We're in a country where there are people from different areas in the country where network reception becomes an issue or a problem. And so there are instances that he has observed that virtual hearings become very difficult sometimes to even have. But one thing he mentions is probably going forward, getting our court system to run on a 24-hour basis. He, in a very light way, even mentions that there are some courts that are currently running 16 hours, and so what it means is that you just need the extra 8 hours. He mentions that they are working around the clock to upgrade the systems to ensure that the court system or the judicial system is able to be upgraded to operate 24 hours across board, which is another thing. Then the cost of litigation. Cost of litigation is another thing that has featured largely. And so when you talk about it, indeed he has made a case and made it quite strongly that when you look at the number of cases that are even pending at the various courts, which is one thing that he is considering, even setting up, a team that would be tracking some of those backlog of cases, so that from time to time, those that need to be fast-tracked, they are able to fast-track them, so that you get a lot of the cases cleared from the court, so you don't have most of those cases, especially those ones that can be dealt with as fast as possible, as swiftly as possible. But the cost of litigation is what brings in the issue of the Legal Aid Commission, which he reckons has been like an orphan over the period. And so he is of the view that, and just as he mentions, since he started acting as the Chief Justice, he has been able to hold a number of discussions with the Attorney General to decide the way forward concerning the Legal Aid Commission, to ensure that they have been able to, as a matter of fact, resource the Legal Aid Commission to give it all the powers, all the financial assistance, all the human resources that the Commission would need to be able to undertake all of its duties to help those that require their services, for which reason they seek such kind of assistance from the Legal Aid Commission. And so all of those are, and indeed, because also when you look at the profile and the wealth of knowledge or expertise that he brings on board, he has done so much work when it comes to electoral laws or electoral reforms and how things can be made better. And so there was that question that was posed to him about our electoral system and even the period within which transition takes place and what have you. And so he has at far and at length been able to address some of those things, and even taking us back to history and telling us about some of the things that they've been able to do over the years, the kinds of committees that he has sat on, referring to some of the constitutional instruments that were drafted earlier to take care of some of those electoral issues. And so all of those suggestions have come afore concerning this vetting indeed. And so indeed a number of things that have come up to more or less tease his knowledge on some of those issues. But there are a number of MPs around that I would seek to get a word or two from them concerning all that has transpired, and even the issue about the tribunals or those special courts that are to help in dealing with some of those cases that you would rather call minor issues. And so that is it. That is what we have had. But that earlier he had given a preliminary remark, in which remark he speaks about the fact that he is ready to work to leave the judiciary better than he has come to meet it. And so he talks about ensuring that there is greater transparency. He talks about efficiency. He talks about accessibility. All of these are some of the things that he noted in his earlier brief remark. And actually, he gives a three-theme or pointer strategy that he is hoping or looking forward to implement once he is given the nod by the House to become the substantive Chief Justice. And one is procedural clarity and predictability, which he explains. He also mentions efficiency and accessibility, which he has explained, and also open justice. And under injustice, he talks about the fact that through appropriate streaming, public summaries, and structured communication, citizens will get to see the work of the court, not just as a verdict. And so what it means is that he is seeking to, along the way, even as he continues to work, once he's given the nod, to ensure that whatever the court does and all the processes and all the actions that the court takes, the public is kept in the loop. The public is abreast of all the issues that there may be. But certainly, and indeed, he can't go without referencing that love affair, how he started from the prison service, talks about how he met the wife and all of that. That was an interesting moment indeed, especially when you have a lot of people who were clearing their throats and shouting love, love, or whispering love, love at the back of it. So it means that indeed it has been a great experience so far, having the Chief Justice nominee answer to some questions. But he makes or takes note of something, that indeed his nomination comes at a very pivotal time in Ghana's democratic journey, a moment that he says is marked by public skepticism. And indeed, you know, there was that particular question, the very first question, even about whether he sees himself qualified or not, and also suggestions by many that his, you know, appointment, more or less, is as a reward from the president from his stance during the 2013 election petition, which he answers squarely and even makes a very good case for himself that he has worked as a justice across the various presidents. Talks about President Kufuor, talks about President Mills, President Mahama, his first term, as well as that of President Nana Addo Dankwa Akufo-Addo, and now President Mahama, the second term, which means, in which case he makes that with all of these different presidents that he has worked under them at the judiciary, it cannot be said of him that his appointment so far is a reward by the president, because he's done so many years working under different presidents, under different regimes at the bar. And when you read his history very well, you know that he has started from somewhere all the way from the High Court, the Court of Appeal, and at the Supreme Court, where indeed that was even in 2008 when he was called to the bar, to the Supreme Court bench. So indeed, he has had a very long stay at the bench for him to, you know, merit this appointment, which is a very good case that he makes. And so, by and far, he has proven and made that point clearly to the committee that he is the man for it. He deserves this appointment, and it is not one that is even based on politics. But interestingly, see, when you listen to what is preliminary which is a strong, you know, commitment that he wants to make, that once he is given the nod, he's going to work to ensure that the face of the judiciary, the status of the judiciary, and all the records, the track records thereof, have been defended and even made better. But let me see if I can engage a few of the members of parliament who are here, who have observed the process so far and have seen for themselves or have heard for themselves some of the responses that the CJ nominee has provided thus far before the appointment committee, to also gauge their own experiences of how things have been. I have two of them here, really, but I'll start from the gentleman, then I'll come to the lady. Usually we say ladies first, but let me start from the gentleman. Honorable, so you have been through the process so far. What do you make of it?
Thank you so much. I've just entered the hall, but in detail, what I can say is that this gentleman, you see, deserves this position. I know him to be one of the good people who can handle this. So I heard you talking about as a reward for him.
That is the assumption.
Exactly. And I think it's true. You see, he has passed through all the political situations, MPP, NDC, all regimes, and he has been there. He has the experience, acumen, exposure, everything to handle the judiciary. So I think he deserves it. Let's give it to him. You see, what worries me so much is about the behavior of the MPP today.
I think we've done with that, huh?
You see, but let me say it. I'm not happy. We are talking about national issues. They should be nationalistic. You understand my point? That lady, the former CJ, is gone. You see, let's talk about how to protect our integrity.
But there are cases that, so far as he has some pending cases in the High Court and the ECOWAS Court, then it is only fair that those substantive cases have been determined before president or the state can go ahead to even get a new chief justice when those cases have not been dealt with.
You see, when did these cases start? You see, you can't use this appointment regime to talk about these cases. You understand my point? You see, if he has sent to the throne of becoming, the head of the judiciary, we can still go ahead to talk about this thing. But now he needs to be a substantive, head of the judiciary. So to me, they should stop all these things. Let's come together. Let's all become nationalistic and go forward. The country, as you speak today, is moving very well in terms of all spheres, socially, economically, politically, and everything. They shouldn't, play the devil's advocate that all is not well. All is well. Ghana is being applauded in this country and all over. So to me, all these things should be behind us and move forward. Thank you.
Thank you so much. Now let me come to the lady indeed to also get your thought. You've been around for quite some time now. What has been your own observation of the vetting process thus far? We're on a health break and we should be back soon. What do you expect also? But what has been your observation of his responses given so far?
Well, so far, so very good. I'm very impressed. From where I sit, from the way he started, you realize that this man has gone through all the ranks. And it's not like a rewarding position that is being given to him. He merits it. In fact, he should have been given Chief Justice long before now. But I think God's time is always the best. And so I can only say I wish him very well, and I pray that he brings some dignity into the justice system of our nation, because we don't want a situation where people were tired, unanimous this, unanimous that, unanimous that. But he should be seen as somebody who is coming to protect the laws of our land and let our justice system work well, because lawyers are very respected people. It got to a time in our nation, you and I can testify that when there are cases, the people outside can just determine how the case is going, and indeed it goes that way. And so I wish him well, and it is my prayer that he delivers very well and leave a legacy, because at this stage, what does he want? He has seen it all. I can only wish him all the best of luck, and I know he's going to help the Attorney General, who is my big brother, to deliver. The nation needs healing. The nation needs people who can bite to keep everybody, including politicians, to check. And so we need people like this, and let's encourage them to safeguard the integrity of our justice system. Thank you.
So that has been Theresa Ladi Awuni, MP for Kaikwe North. Earlier I engaged the Honorable Eric Baffoe, MP for Amenfi West, on their view so far, how they have seen the vetting process vis-a-vis the responses of the nominee himself. Just about now, I see the chairperson of the committee make a comeback into the vetting room. Indeed, what it is expected is that pretty shortly after that, and per the time given, the 20 minutes given, we are just left with about 4 minutes, which means that just around 5:10 p.m. the session should be back in action. But you would recall that we've had a trajectory over the period since this nomination, somewhere earlier in April this year. The minority has always had a stance. They've always had this stance that when you look at the work of the Parliament Committee, which today the leader sought to address, it has not been that which they believe followed due process. And so they've always, spoken about that. And even last week, in fact, a number of press conferences have been held in which they have sought to address this issue. Even today, after they had walked out of the vetting room, they addressed the press and reiterated the point again that, see, there are about 6 active cases of the Chief Justice, the former Gertrude Arabe Sabato Kodo, which are pending when you go to the High Court. A number of them, one that I would say is my favorite, which she makes the case that if she has been removed as the Chief Justice, she should still be given that chance to serve on the Supreme Court bench. One which really, and as lawyers will tell you, would require some constitutional interpretation, and which means that at all costs, that case should be transferred or transmitted from the High Court to the Supreme Court. And then there are other ones as well, challenging the processes that led to her removal. And she is also at the ECOWAS court. Right after walking out of the vetting process, they held that presser in which Kwame Anyumeduentri, who is one of the sponsors of a motion that was sent to the Speaker asking that this vetting be not held, addressed the press again to make that case yet again that.
Right, so that's Christian Yale, who is our parliamentary correspondent, updating us on what exactly has gone on. And many of you have been following, including our guest who's also joined us on Zoom. He's been with us right from the inception, and I'm sure that Professor David Abdullahi has also been following after the long back and forth between the minority and the majority leader. Finally, the vetting has commenced, what we're all looking forward to. And the Justice nominee, I beg your pardon, the Chief Justice nominee has actually started answering some questions. And I want to take the preliminary thoughts of Professor David Abdullahi, who is a governance expert, and he's with us. Prof, thank you for staying with us right through the beginning up until now. What would your initial thoughts be about some of the questions that have been posed and the answers that have also been given as a result of those questions?
Thank you very much. First, I'm very impressed with the way he answered questions and also his thought process of what he intends to do if he is given the nod. I also think it's not just the idea of what he's going to do, the thought process of bringing innovation into the current judicial process, employing artificial intelligence, moving towards a 24-hour court, and so on and so forth. I think this is the right direction because we're in a new era where technology is very important in the dispensation of justice. And if he can, or if he's given the nod and he can be able to introduce all these things, it will bring some sanity into the process and making sure that most of the backlogs and all the suggestions you bring into fore will work. And I also think he has the temperament. If you can see how he speaks, he has the temperament and also, the confidence based upon experience and the fact that he rose from the lower ranks up to where he is now in the judiciary to be able to deliver what he's looking at to bring forth. Yes.
Yeah, it's interesting that two things that he said that stood with me or that, are still frontal that I would want us to talk about. One has to do with the backlog which he complained about, and then, empaneling judges for, specific cases. And just by way of a reminder to our viewers, we are also simulcasting this broadcast. So we are also on 3FM 92.7. So in case you are just about leaving or you can tune in and continue listening to this conversation and the vetting as well. In a few minutes, the vetting will continue, or of course we can see on your screens that the committee is getting back to their chair, and then also we are expecting the nominee to also take his chair so that the vetting continues. But Prof, talk to us about this major concern where he says that in Sawam prison, which is one of the most popular prisons we have in the country, was built to accommodate just about 851. But as of today, they are having in excess of over 3,000 individuals, fellow human beings, locked up in there, and has made proposals or suggestions as to how we can gradually, decongest the prison. What do you make of some of the proposals he's making? He's talking about AI, and probably some people have been given bail but cannot meet the conditions, and a number of issues he thinks that are the challenge, but we need solutions to it. What did you make of his answer to that?
First, he didn't only talk about in Sawan, he also talked about Kumasi, yes. and so I think apart from the suggestions he has made, I think the government needs to help in being able to build, expand the prisons. I mean, build more infrastructure. Now, the infrastructure will support the technology that is going to be employed to be able to make sure that that happens. And apart from that, I think what is also important is it's not just only the technology. You must have, the data and the statistics to make sure that you know who is where and what time and when they were actually sent to prison and what should happen. But for the suggestions she's made, I think they are very spot on. The most important thing is not just saying it. We just hope when he gets in, he has the opportunity to be able to leave an imprint and bring about solutions that would move the process forward, knowing that if he's approved, he doesn't have so much time left before he goes on retirement. Apart from that, I think all what he has said, I agree. But let's just also talk about the fact that you cannot build a prison during that time, and now we are in an era where the population has grown and you didn't build infrastructure. The government should be held responsible, or they should listen to that particular point and be able to do the needful.
Yeah, and that actually ties into another point he made about the fact that now a lot of Ghanaians are quite interested in running to court with the least issue. They want to go to court for settlement, and that is one of the reasons why there seems to be a backlog of cases at our courts. Well, Prof, kindly hold on for me or stay with us. We are going back to join the feed to continue with the vetting.
Okay.
You are entitled to 3 questions.
Thank you, Chairman. My Lord, congratulations.
Thank you very much.
Thank you. My Lord, your nomination as Chief Justice marks not just seniority, but a symbolic restoration of trust, tradition, and constitutional renewal or resetting. Now, the question I have for you from the above opinion is, what specific reforms will you implement to restore credibility and revive the judicial sinking image?
Thank you, Honorable Chair. I think the image of the judicial service has gone down. A lot of people have a lot of problems with the service, particularly with regard to the fact that cases keep so long in courts. People go to courts hoping their cases hoping that their case will be heard within a very short period. And the cases, but there are some now. The average number of years that a simple civil case can stay in court is about 3 years or 4 years. There are some cases that have been in court for so long. There are also criminal cases, as I said earlier, where people are facing trial over a long period. All these affects people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, the District Assembly, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts, together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the reports that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The other thing is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases, and that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller," and then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, oh, that I saw the judge talking to that lady. So it is his sister, it is his daughter, it is his girlfriend. So go and see her. So people give their monies to people, and then they don't, once they have given the money out, they have bribed the judge. They have given, they are okay. So such people go about saying that, oh, the judges have taken their money. And once the judge has taken their money and they get their judgment, they are okay. While the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad notes among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in there, then we can tackle it. So if we sensitize people about ADR, that there's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaints unit, but people are not even complained there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole thing, reinforce it, so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people say that, well, I'm not going to court, I'm going to do what we call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think for about 2 or 3 years now, we have a situation where applications that are filed do not have return dates. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years. So immediately I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent?
Thank you, Madam Chair. I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, a Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. But then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these three groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these three lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you'll be a good material, so apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than one or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice. And so with this kind of nomination from these three people, how people can talk about political, I can't really understand. With the Chief Justice, the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the president has a say. And at least that is what our Constitution says. If Ghanaians believe that the Constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honourable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honourable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honourable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination.
Thank you.
And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment as part of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the my mic is... My Lord, I want to find out from you, do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, you see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, as you rightly said, the nomination and appointment and everything is done by the president. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's what I'm saying, that as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes.
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with. But as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of the current lists, on the advice of the Judicial Council, 41 persons' names were sent to the presidency. And only 4 out of the 41 names were taken out. And even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on I was pleading with the president that we needed to have these people sworn in so that the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of the 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how would I be able to convince such a person that it's not the president actually who put the 37 people there. We did. He only took our advice. So it is not as if, people's suspicions are going about that. You cannot go about trying to assuage people. You can do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, you as, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. You become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year, all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. it is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then parliament. Whilst the lower bench have their salaries tied to normal civil service, civil servants. And worst of all, the JUSAC, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court. We are not known more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions, because whilst we struggle, whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regions, regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
That will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yarga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process because there are a number of suits pending challenging the removal of the previous Chief Justice. They are asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing, and as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction, or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Sito and other things came up and said that that was right. But the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood. But a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, when President Mahama was declared, and he was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Kufuor from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was, the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and would have been enforced by Article 1 and 2. The same thing would have happened in 2020, when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice, there's no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the case, the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneled. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he'll give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you are part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean,
the court was happy that they had finally resolved the matter. It was basically a land matter, But what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted, or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, yes. That this case lasted 40 years.
I get honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3,
yes.
Attempts to get justice?
Yes.
And if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review, that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court? Because there's too much caseload at the Supreme Court level, which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku, so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking in view of the discussions going on about amending and reviewing our Constitution?
Honorable Chair, this is a very interesting trajectory that this question is taking. People will, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 + 9, that's 10, as our Constitution provides, and not go up, is dependent upon the jurisdiction of the court, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where cases civil cases or whatever, can go all the way to their Supreme Courts. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal with review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there is a criminal case, Ali Kasida, started in my village at Gozo, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution, that a person has a right to go all the way to the Supreme Court, people are prepared to. And now, you see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You will find that about 35 of that number of years happened in the lower trial courts. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where proceedings were supposed to be adopted, you'll find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to ask it to arrange the processes so filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement, the writ, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett-Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2. It's just a view. My Lordship, Paul Baffoe-Bonnie, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree. I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training. We are doing substandard work that the products are substandard, but that is not the case. We are also not overproducing. Actually, you see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together, from 18th century, Mensa Saba and all that, we're not up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. A lot of them have migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even in practice. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, the law is such that the District Assembly law, the Local Government Act, expects every local government to have a legal department. And when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than 1 person. Every local assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or ply their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Koforidua, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the ones, the number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. The headmaster of my school, the best secondary school in Ghana, Korogu Mase, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which he'll be doing at the end of November, then when he retires, then he will pick his law, he'll go and do Galamsey. No, not the Galamsey. The lawyers understand legal Galamsey.
Are you talking about Galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So my honorable chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further questions?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America, of the U.S. That is, they are what we call a constitutional court. But Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We will not be able to work at all. The only thing that we have to, there are 2 things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. if we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court, by an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal, or, for example, criminal cases can only end up at a high court or the regional tribunals or whatever, then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the Honorable Nominee. We have Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedo Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family. We have Marini Kwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Anantahini. Forgive me if I don't pronounce it well. Typical Aigbe boy pronouncing three names. Then we have Nana Dr. Baffoe-Bonnie, Nominee in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King, Reverend Pastor Tete, Assemblies of God. Then we have all students of Konongo Odumasi Secondary School. We have Felix Abuaji, Esquire. We have Justice Kusi Minka, Esquire. We have Koku Chiramantin, Esquire. We have Esuo Yao Benin. We have Captain Collins Fosu. We have Kwame JB. We have Kwame Ousu. Honorable members, we also have Marietta Ajewa Brew. The legal counsel to His Excellency the President of the Republic of Ghana. We have Benedict Bob Derry, Director of Prisons Operations. We also have Francis Omani Ado, Deputy Director General of Prisons in our midst. Honorable members, don't take offense in the event I do not mention your name. At the back, I have Nana Sangba Jafla II, Paramount Chief of Sampa Traditional Area, also representing His Royal Majesty Otumfo Osei-Tutu. We have Nana Baffoe-Bonnie Chichikra II, member of Asante-Hini's delegation. Then we have Berima Yao Koda upon Monwurahini of Achim Ebuakwa traditional area. Then we have Togbi Teprehodo the fourth. I've eaten the okra, so I can pronounce this one very well. He is the Paramount Chief of Amfoga, the President of the Volta Regional House of Chiefs, President of the Volta Regional House of Chiefs, representatives from the National House of Chiefs, and is also a member of the Judicial Council. Then we have Nana Dr. Baffoe-Bonnie, the Chief of Nominee. I think I have announced. No, you haven't. 16. I've done it. Now, back to the tall list containing the Supreme Court, Court of Appeal, and other judges. My lords and my ladies, I will urge the Hansard Department to capture every name that I have pronounced here, preface it with my lord or my ladyship, if I don't pronounce it. We have Gabriel Poma, Justice of the Supreme Court. We have Avril Lovelace Johnson, Justice of the Supreme Court. We have Richard Ajay Frimpong, Justice of the Supreme Court. We have SKA, my very good friend, Asiedu, Justice of the Supreme Court. We have another good friend, Justice Tanko Amadou of the Supreme Court. We have Ernest Gaiu, Justice of the Supreme Court. We have Henry Kofi, Justice of the Supreme Court. We have Yao Asari, Justice of the Supreme Court. We have Justice Senyo Jamope, Justice of the Supreme Court. We have Justice Bright Mensah, Justice of the Supreme Court. We have Justice Kweku Akabofo, Supreme Court. We have Justice Dennis Ajay, Supreme Court. We have Justice Battles Kujo, Supreme Court. We have Justice Hafisata Amaliboba, Supreme Court. We have Justice Johnson Mbila, Supreme Court. No, member of the judiciary. Member of the judiciary. Yeah, Judicial Council. We have Samuel Afote, Judicial Council member. We have Ambassador Ekuya Sana Danso, Judicial Council member. Then I have announced Togwi Teprehodo already, but he's here again, Judicial Council member. We have Dennis Ayram Fome, Judicial Council member. Now we have Georgina Mensah Dacha, Court of Appeal. We have Jennifer Abna Dazi, Court of Appeal. We have Kofi Akrowia, Court of Appeal. We have Justice Pamela Kranti, Court of Appeal. We have Yao Onyamiye, Jacobo, Court of Appeal. We have Shilaminta, Court of Appeal. Gifty Dacham, Court of Appeal. Professor Olivia Anku Chede, Court of Appeal. Dr. Bampuru, Court of Appeal.
Hello, good evening. It's News 360 coming to you live from the News Hub here at Adesawe Kanda. I am Portia Gabo.
And I am Martin Asiedu Date. Coming up for the next 1 hour, these are the headlines.
News 360 Headlines is brought to you by
Flamingo Paint,
Pepsodent Charcoal and Pepsodent Herbal,
EcoBank.
Minority on the Appointments Committee reject nomination of Justice Paul Baffoe-Bonnie as Chief Justice as they stage walkout.
And also coming up tonight, organized labor urges calm among workers who have expressed disappointment over the 9% increase in base pay.